We're live. This is Tuesday, March 11th. This is, we went to the floor in the middle of hearings at 5. We got off the floor now at 7. We are going to continue with bill hearings, and we were, when we last left, we were on House Bill 1460, and we have 2 witnesses that testify. And Delegate Young, you were very humble and very kind to do that, which was the right thing to do. Thank you for doing that. So we're going to continue with your bill. We still have, for the committee to know, we have House Bill 1472, 1351, 1474, 1355, 1473, and 1399 left for tonight. So you're going to be here a long time, okay? So Delegate Young, thank you for your patience, and everyone else that has been waiting. We're not disrespectful. It's just that it is crossover week, all right? But we're here now. Delegate Young, would you like to get started? And in this committee, Delegate Young, you're not just go ahead and give us your testimony. No, it goes by itself. Did you have the light? Okay.
Thank you, Madam Chair and members of the Health and Government Operations Committee. I want to first and foremost thank you all for the accommodation that you afforded some of my panelists earlier today. It was very kind of you as well, Madam Chair, and your committee to indulge in that. And I just want to first start off by saying thank you. My name is Delegate Kaylin Young of the 45th Legislative District here in support of House Bill 1460. Colleagues, when we all started our term back in 2023, and for those who are newer, I guess very recently, we all took an oath of office. And that oath of office is to support the Constitution of the United States. And today, that is why I'm here. As a legislator, but also as a civil rights attorney, I'm deeply committed to defending the constitutional rights of all Marylanders. House Bill 1460 is a testament to that commitment. One goal for today's bill is to make sure that those individuals who have been silenced or whose voices have not been heard so much, they deserve a platform too in this arena. So for those Muslim and Arab Americans, Marylanders, that's why I put this bill in. Secondly, I know how to count votes, and I understand the large hill to climb to get a bill like this, not only out of this chamber, but also across the street. So I understand that, and I want you all to understand that there are many reasons why we may bring a piece of legislation. And the other reason that I bring this legislation is not necessarily because I think that we will pass this bill, although I will ask you for your favorable report. But I'm here to lay the foundation for future litigation, to set the public record of where people are in Maryland about this particular document that these businesses must sign before they can do business here in the state of Maryland. As many of you know, in order to do business with the state of Maryland, you have to sign a number of certifications. Included in those certifications is the first one, which is an anti-discrimination certification. I want to make sure that's clear because many will tell you that part of the reason of the latter certification is anti-discrimination, but we cover that in the very first certification. And as we get down to the later portions of those certifications, we reach a certification that I find to be a very clear prima facie, in other words, on its face, violation of the First Amendment of the Constitution of the United States that we all swore an oath to protect and defend. Additionally, there are at least 3 other clauses of the Constitution that I've identified that this that this certification might violate. And those are the Commerce Clause, the Equal Protection Clause, and the Due Process Clause. As it pertains to the First Amendment, we mandate anyone who wants to do business with the state of Maryland we compel them to identify a particular political point of view. and we restrict them from being able to express themselves in what we know that the Supreme Court has defined as protected political speech. Protected political speech receives the highest level of scrutiny when analyzed by the courts, a strict scrutiny, which requires that the government have a compelling interest, and that when it shows that compelling interest, that the remedy is narrowly tailored in the least restrictive means. As it pertains to the Commerce Clause, we require businesses to identify a political point of view, whether they are in-state or out-of-state. Therefore, we might be interfering with interstate commerce, which is preserved for the Congress. Equal protection, we discriminate against businesses based on political viewpoints, and that undermines the principles of fairness and equality enshrined in our Constitution. Due process, the vague language of the certifications, coupled with the penalty of perjury, which carries a sentence of up to 10 years and $250,000 fine under Maryland law, exposes businesses to penalties and creates a chilling effect on free expression. And we must acknowledge that the country in question has engaged in actions that warrant protests from certain people's points of view. I'm not asking you to opine on those points of view or how you feel about that particular country. However, what is true is that those actions, in many people's points of view, rise to the occasion that they might want to speak out and act. Marylanders, in any respect, retain the freedom to respond through peaceful means, such as boycotts. And why is this bill good for Maryland? Passing this bill aligns with Maryland's economic interests and our commitment to diversity. Economic inclusivity in these challenging times must be preserved by this body. We must ensure that our state remains open for business for all, without imposing ideological tests that exclude qualified Marylanders from participating in state contracts. Diversity, we are a state that welcomes diversity. Our strengths lie in it, even in this chamber. By countering national trends and those that seek to suppress dissenting voices, we reaffirm Maryland as a welcoming state that values all perspectives. We all took an oath, once again, to protect the constitutions of Maryland and of the United States. And it's our duty to allow individuals to express themselves freely. And as we look at our budgetary challenges, and as we try to create an economy that is better for business, that is growing, we need to make sure that all Marylanders feel free to participate, that any Marylander that wants to engage in free enterprise with our state has the ability to do so without having to make a political statement. Put plainly, businesses don't want to have this conversation. So why do we make them? House Bill 1460 is both the right thing to do, and it's also the best course of action for our state. It upholds our constitutional values, it fosters an inclusive economy, and it reinforces our state's commitment to justice and free expression. So I urge you all to support this bill, and I ask for a favorable report. Thank you, Madam Chair.
Thank you for your testimony. Do you have a panel that you want to bring up?
I'm happy to entertain whoever you might want to bring up. The panel that I had earlier was the primary panel.
Okay. Let me see. Let me go through some of the, before I open it up for question. Philip Atedo? He's not here. He's not here? Okay. Lawrence Wapre, if you can come up. Arif Ramadan? Okay. Rondot Copperstein?
Madam Chair, if
Yes.
your staff could let the Environment and Transportation Committee know that I'm currently on your dais.
Okay. Okay. can you do me a favor? Have Michelle call the Environmental Transportation Committee. You have another bill hearing there?
Yes, ma'am.
So let's just ask you, hold on a minute, sir. Let me ask the sponsor question so he can go testify, and then I'll take you guys, okay? Are there any questions for the delegate regarding the testimony he just gave? Okay. Delegate Hill.
Delegate Hamilton, do you have what it is that people are trying to know the building up is?
Yes. And I can make sure that it's in everybody's inboxes. Would you like me to, let me just quickly read it to the record.
I also have this individual and the virtual.
Okay.
Prohibiting discriminatory boycotts of Israel. In preparing its bid or proposal of this project, the bidder or offerer has considered all bid proposals submitted from qualified potential subcontractors and suppliers, and has not, in the solicitation, selection, or commercial treatment of any subcontractor, vendor, or supplier, refused to transact or terminate business activities or taken other actions intended to limit commercial relations with a person or entity on the basis of Israeli national origin or residence or incorporation in Israel and its territories. The bidder or offerer also has not retaliated against any person or other entity for reporting such refusal, termination, or commercially limiting activities, without limiting any other provision of the solicitation for bid proposal for this project. It is understood and agreed that if this certification is false, such false certification will constitute grounds for the state to reject the bid or proposal submitted by the bidder or offerer on this project and terminate any contract awarded based on the bid or proposal. And it further states further down that I do solemnly declare and affirm under the penalties of perjury that the contents of this affidavit are true, correct, to my best of my knowledge, information, and belief.
Can you please get closer to the mic?
I'm sorry.
Thank you.
Are there other similar statements for Sudan, Iran, other countries? Do we have similar statements? And if so, how many other countries do we do the same thing for?
We don't do the same thing in the sense of we're not restricting folks from being able to speak. In this particular instance, we restrict an expression which is protected speech under the First Amendment. As it pertains to the Congo, we prevent people from doing business with the Congo under the state finance and procurement article. As it pertains to Iran, it's similar, but again, as passed under a statute and the state finance and procurement article. And I believe those are the only two countries, if I'm correct. But I could be corrected on that, but I think I'm right from what I'm looking at. Yep.
Delegate Alston.
Chair, and thank you, Delegate, for your work on this bill. What I want to know is, do you believe it's possible to be opposed to the government of Israel, but not be opposed to Jewish people?
Absolutely.
And can you explain?
Sure. I think as we look at, here's the reality, I think. It's often, I'm going to speak plainly, if y'all would indulge me. It's often conflated. And we have to keep in mind that we have the right to criticize our own government. So if we can criticize our own government, I see no circumstance where we can't criticize another. Oftentimes, because Israel is the only Jewish state, there are those who might see it as anti-Semitic. I'm sympathetic to those viewpoints because this is very personal for everybody. But at the same time, I think that there's a distinction that must be made when we talk about a particular regime. And in the current instance, we have a Likud party led by Netanyahu that has taken actions that people find egregious. And protesting that party and that leader is not anti-Semitic. It's the same manner that I might protest Iran and their leader, China and their leader, North Korea and their leader. If I see a warmonger, I'm going to protest a warmonger. It's as simple as that.
Okay, all right. So because you don't get an opportunity after the unfavorable to be able to comment, I'm going to ask you what the unfavorable, what they state. Is that all right?
Yes, Madam Chair.
So I have the Jewish Community Relations Council. They wrote a letter in opposition. And they said that Maryland is one of 38 states that have passed bills and executive orders designed to discourage boycotts of Israel. Many of them have been passed with broad bipartisan support. BDS seeks to delegitimize and demonize the state of Israel. It says, what will you say to that?
I would say, first and foremost, can you repeat the beginning of it? I lost my train of thought.
It says that Maryland is one of 38
That's right. Thank
states.
you. That's what I needed to trigger. Thank you.
Yeah.
I would first and foremost point to the fact that many states' laws have been struck down on First Amendment grounds. And therefore, we've seen precedent where, depending on the language, these laws are removed. I would also point to the litigation that happened, Sadiq Ali versus Hogan, where while the case was dismissed on standing grounds, it left open the opportunity, which is what I started with, for us to bring back more litigation to challenge this certification. The grounds that it lost on is because Mr. Ali did not actually try to secure a contract. And so we will actually seek to secure contracts. I would also argue that he did not argue against the fact that there's a perjury clause here that jeopardizes his freedom. And the court stated that because he would have required him to put his freedom in jeopardy. And I think that was inappropriate. And the second piece, Madam Chair.
There's a Baltimore Jewish Council, an agency of the Associated. They also opposed, and they wrote, the proponents of this bill support the boycott, divestment, and sanctions BDS movement against Israel. BDS is an international campaign to delegitimize, I can't, what is it with me today?
Yes,
This work tonight, okay? And pressure Israel through the diplomatic, financial, professional, academic, and cultural isolation of Israel. Israeli individuals, Israeli institutions, and increasingly Jews who support Israel's right to exist. What will you say to that?
My response is that Israel has a right to exist, but it does not have a right to exist as an apartheid state.
Okay. I just wanted to give you an opportunity because you don't get to come back, okay? For you to be able to reply to some of the opposition, okay?
Madam
ma'am.
Chair, Madam Chair, I was able to join virtually. If I can also share and share.
Let me ask you a question.
Sure.
Okay, because we're supposed to ask you a question. I know that we kind of rushed you when you left, and that's why I allowed for you to come in with the virtually. So tell us, what can you add to it?
Sure. So what I would say is that the movement, BDS movement, is a movement. It reflects a time-honored tradition of peacefully protesting the policies of a government. And we saw this in South Africa. The BDS movement in South Africa helped to defeat apartheid in that country. And this is a First Amendment protected right for all Americans. We as Americans in our country abide by the laws of the Constitution. And the Constitution governs the law. It is the law of our land. It governs our nation. And regardless of what our personal views are on individuals or policies, the reality is that, as Delegate Young mentioned, we should have the right to be able to protest. If I wanted to protest the government of Saudi Arabia, if I wanted to protest the government of Iran, if I wanted to protest against China or Russia, then it would not be the place of the state of Maryland to criticize me or punish me or prohibit my company from being able to apply for a contract with the state of Maryland because of my personal beliefs regarding these different countries. And I think that that's where this disparity happens. I think that it's perfectly fine for people to have different views on political issues. What's not okay is when those views are superimposed upon policies that disparately impact various communities who are marginalized in some cases and who simply want to have the First Amendment right to be able to protect their free speech and express their views on different issues without being told that if you do so, then you no longer are qualified to bid for a contract with the state of Maryland because we're going to punish you. And I think that that's where that distinction happens. This, as Delegate Young mentioned, while there are executive orders and bills and laws in other states that have passed with bipartisan support, there are also many states that have struck down these bills. And unfortunately, there has been a concerted movement to conflate the criticism of the state of Israel, which is legitimate on many grounds, with anti-Semitism. And I think that it's really important to also center the Jewish community's voice in this. And the Jewish community is also not a monolith. You will hear from witnesses who identify as Jewish, and they themselves vehemently oppose the fact that we have an anti-BDS executive order active within our state. And that executive order was actually passed after multiple failed attempts to pass that same legislation through the state legislature. So prior to 2017, the executive order was signed by Governor Larry Hogan as a favor, or as under the pressure of, or the request of his supporters after multiple failed attempts to pass this legislation through the General Assembly. So it's really troubling that we have anything like this on the record in the state of Maryland, and we hope that the committee really scrutinizes that piece of paper that Delegate Young read aloud, that any company that applies for a contract with the state of Maryland is required to essentially sign a pledge under perjury saying that they would not boycott a foreign government. Otherwise, they would be prohibited from being able to apply for a state contract.
Thank you. Any other questions? All right. Delegate Rosenberg.
Just real quick, you referred to Israel as an apartheid state. Did the South African government under the apartheid system give blacks the right to vote?
I'm not familiar with all of the specifics of the apartheid in South Africa and where the rights were.
It's my understanding they did not, whereas Israel does give Arabs who live in Israel itself, not on the West Bank, granted, the right to vote is one difference.
Thank you for that, Delegate.
You cannot, because he's talking to the sponsor, okay? Thank you.
You know, one of the things that I appreciated the most in my journey with this piece of legislation is an engagement with the BJC and with Bruce Briano, where we were able to have real dialogue and engage and learn from each other. And so, you know, one thing that I'm going to ask of you, Delegate Rosenberg, City Forever, is that we have a dialogue too about some of this, where there's things that I can learn. But I also believe that we also have to just make sure that we're upholding the Constitution. So if I offended anybody with that statement, I do want to apologize. But I'm very serious about why I think that this bill, or at least the certification, is inappropriate for the state of Maryland.
Thank you.
Thank you.
Delegate Johnson.
Thank you, Madam Chair. And Delegate, I was reading the fiscal note and the bill, and is there a difference in freedom of speech and engaging in a boycott? Because I see it says on the fiscal note a discriminatory boycott. So can you tell us what is the difference there in freedom of speech and engaging in a discriminatory boycott?
Well, I wouldn't purport to define the term as the folks in the fiscal note might have leveraged it. In my opinion, and in the opinion of the Supreme Court of the United States, a boycott is free speech, and it's protected speech.
Okay, thank you. Thank you, Madam Chair.
All right. Any other questions? I don't see any other. Thank you, Delegate, for your patience. And we let ENT know that you were here. Thank you, Ms. Chaudhry, for coming back and being with us as well. So we're a little bit more calm now, and we're able to hear you both. And I'm going to go on now and call the rest and see who else is here. Is there anyone else virtually? Two more virtually?
Madam Chair, I'll return.
Thank you. All right, why don't I, let me call from the people who are here, can you just tell me your name? Who's waiting? Your name?
Samantha Faubert.
Samantha, 1 second. Can you please come forward? And who else?
Mary Ella Jordak.
Mary Ella, will you please come forward? Your name?
Dana Vickers Shelley.
Will you please come forward? Insert your name?
Grand Prix.
What was the name?
Grand Prix, like.
Lawrence Grand Prix, come forward. Why don't we go with you four, okay? And thank you for waiting again and for being patient, all right? Who would like to get started?
I can start. My name is Samantha Faubert. I'm a resident of Annapolis, Maryland, and I'm here to speak about HB 1460. I hope everybody will vote favorably for it. As an American, I love my freedom of speech. I love the freedom to disagree with others and come together and resolution, learn new things, and actually ultimately build an amazing community and an amazing country. I believe in the ability for businesses and individuals to boycott, and especially when it comes to Israel, there are a multitude of reasons of why somebody may want to boycott. Back in March 12th, 2024, there was a line of people in Gaza who were starving and waiting for food and were massacred. Over 100 people died that day. Al-Shifa Hospital was raided back in December of 2023. Washington Post did a report saying that there were no weapons found and no military there. And yet Al-Shifa was raided a second time back in April of 2024, as reported by NPR and Al Jazeera. And there was somebody who was kidnapped. Press was taken hostage. They were stripped and handcuffed and interrogated and held hostage. Al Jazeera had to call on the person and be like, hey, we want a reporter back. It didn't matter because after he was released, 3 months later, they targeted him and killed him. Another reason is to stand with the U.S. Air Force. A lot of y'all are aware of Aaron Bushnell, who, in an act of protest, self-immolated outside of the Israeli embassy in Washington, D.C. He brought a lot of information to light, and more Air Force service members have voluntarily quit. I can go on and on about other reasons. I hope you will vote favorably. I also heard the questions about, does this mean that you're against Jewish people? Israelis, sorry, I'll finish. There are Israelis that protest every day in Tel Aviv to bring back the hostages home. I wish to see them return to their families and for the bombing to stop. And there's people in the West Bank that are there peacefully and trying to watch and make sure that they are not, Palestinians are not attacked in the West Bank. Thank you.
I'll go. Good evening. Thank you all for your patience. I know this has been a long day for you. My name is Mary Ella Jordak. I'm here today to express my strong support of HB 1460. I'm a second-generation business owner in our great state. My name is on my business, and so are my morals. I openly list which organizations I donate money or time to and which causes I'm aligned with. I firmly believe that where you spend your money, or where you don't, is a fundamental part of being a civically minded individual. And I'm not alone in that thinking. The First Amendment upholds our ability to engage in free speech, as do rulings from the Supreme Court. In fact, they ruled that boycotting is, and I quote, the highest rung on the hierarchy of First Amendment values. I find it deeply concerning that the way I operate my business, specifically the fact that I engage in free and protected political speech, is limited because of an executive order. And furthermore, regardless of whether or not a business owner has a moral stake in speaking out against a foreign country, the state of Maryland is compelling the speech of these entities under the penalty of perjury. This is an unjust practice for our state to engage in. In essence, this existing executive order allows the state to boycott boycotters and to take part in political action against citizens exercising their First Amendment rights. I'm also aware that laws like this are portrayed by detractors as anti-Semitic. I would like to take a beat to affirm that my choice to boycott Israel is not a boycott of people or of religion. It is of a state that has engaged in egregious violations of international law, including collective punishment, settlements and annexation, apartheid, and refusing the right of refugees' return. This bill is not anti-Semitic, and claiming this clear untruth weaponizes very real suffering to silence those who refuse to abide in justice. We are capable of holding complex truths as coexistent. So yes, anti-Semitism exists. Yes, community and leaders alike must fight it fiercely. And also, yes, we must protect our ability to speak out against injustice. It is past time that Maryland upholds both the Supreme Court's ruling as well as the fundamental law of the land through our precious First Amendment. As such, I would ask that the committee please find a favorable report for HB 1460. Thank you.
Will you come next, please? Give us your testimony.
Good evening, Chair Pena Melnick and committee members. I'm Dana Vickers-Shelley, Executive Director of the ACLU of Maryland, and given the imperative of our country's First Amendment, I'm here to express our strong support for HB 1460. Governor Hogan's 2017 executive order bars government contracts from being awarded to companies that engage in boycotts, divestment from, or sanctions against Israel. We believe this order was and is unconstitutional. It penalizes businesses based on their political beliefs rather than on their qualifications to fulfill contractual obligations. HB 1460 would repeal these arbitrary requirements and ensure that government contracts are awarded on merit, not political ideology. The bill protects the First Amendment rights of companies by affirming that they don't have to choose between economic opportunities or their constitutional rights. The Supreme Court has long held that boycotts are a form of protected speech. The Supreme Court has long held that boycotts are a form of protected speech. Maryland's executive order, despite this, effectively forces companies to choose between their livelihoods and their rights. Not only does this current policy create a dangerous precedent, it contradicts Maryland as the free state's historic reputation. Boycotts have been a powerful and fundamental tool over decades for political and social change, from movements for women's suffrage, civil rights, gay liberation, the labor movement, to international human rights advocacy. The ACLU of Maryland firmly opposes any government efforts to punish certain businesses for their political beliefs or to weaponize state contracts to restrict political expression. We urge you to pass HB 1460 and reaffirm Maryland's commitment to fairness and to free speech. Thank you so much.
For your testimony today. Next, please.
Lawrence Grand Prix, Director of Research for Leaders of a Beautiful Struggle. Thank you, Chair, urging a favorable report. Our organization has been very clear that we believe there are links between the oppression of Black folks in Maryland and the oppression of Palestinians. But the affirmation of this bill does not require you agree with that view. The question is, should it be the role of the state of Maryland to legislate how private citizens' political stances can determine if they can make a living? When it comes to business in the state of Maryland, we believe the core question is, can you do the job fiscally responsibly, and aligning with the values of the people of Maryland. The current executive order puts a loyalty test to the state of Israel above those fundamental questions and creates the perception that we're more beholden to a foreign nation than the rights of American citizens. But that begs the question of what are people's views on this issue. A University of Maryland poll found that 52% of Republicans and 82% of Democrats are against laws that penalize boycotting of Israel. Regardless of what you felt about BDS, they found that people did not support the state penalizing people that chose to engage in constitutional protected speech. It does not matter if you pull the contracts, it's the threat of pulling them that creates the chilling effect. For example, if I got a contract and created a website and I chose not to use the service Wix, which is based in Israel, because I don't want my money going overseas, I want to support a local Black company. That act could trigger my contract being pulled because I chose not to use an Israeli business because they are foreign. This is the reality of this question. And finally, I want to talk about the long history of solidarity between Blacks and Palestinians and how that impacts contracting. Stokely Carmichael, formerly Kwame Ture, former head of the Student Nonviolent Coordinating Committee, started off as a supporter of Israel, then began to question it. He also became a founder of Black Power, which inspired the minority contracting movement. Under this bill, the founder of the minority contracting movement, or the energy that pushed it, will have his contract cut because he dared to question the state of Israel. Not to mention Malcolm X, one of the last thing he wrote was a critique of Zionism, which raises the question of all of our Black, Muslim, and Muslim brothers and sisters who could have their contracts pulled for the act of expressing solidarity with other Muslims experiencing oppression in Palestine. We urge you to support this bill.
Thanks for being here and for the work you do. Let me open it up for questions before you get up. Are there any questions for this panel? I have Delegate Olston first, followed by Delegate Rosenberg, followed by Delegate Johnson.
Thank you, Madam Chair. My question is for the ACLU. Have you all filed lawsuit or sought any kind of injunctive relief in reference to this provision under the procurement article? And if not, why not?
We have not at this time. We are working on a range of, over the years, free speech, immigrants' rights, voting rights, and this is not a matter that we've made a decision on filing a lawsuit on yet.
Thank you.
Delegate Rosenberg.
For the ACLU, in Citizens United, when the Supreme Court extended First Amendment rights to businesses, you opposed that aspect of the decision, didn't you?
Correct. Correct.
But you are arguing today that corporations do have First Amendment rights, contrary to your position there.
Yes.
Thank you.
Delegate Johnson.
Thank you, Madam Chair. And maybe you can help, because I'm a little confused about this. Maybe you can help clear this up for me. So in the procurement articles and contracts, does it say boycotts or does it say discriminatory boycotts?
It talks about boycotts, is my understanding.
Because there's a big difference.
A boycott.
It is.
A boycott is a form of protected speech.
Okay, but a discriminatory boycott is knowingly aid or assist any other person in participating in a discriminatory boycott. That is a boycott that occurs when a person makes a business agreement with a foreign government, person, or international organization without authorization under federal law that enforces restrictions on business relationships based on domestic individuals' race, color, religion, sex, sexual orientation, disability, gender identity, or national origin. So there is a difference.
I would say this. The ACLU protects free speech. We protect hateful speech. It is speech that is being protected. So in the description that the delegate has raised, and I was listening to the definition as I'm hearing it for the first time this evening, speech, a boycott is protected speech, even if it is not what we want to hear or not being conducted in a way that, or words are being used that we don't like to hear. So a boycott is protected free speech.
Okay, well, I guess I need to find out for sure if it's in the documents discriminatory boycott, but thank you. Thank you, Madam Chair.
I have Delegate Hill.
Thank you. I want to be clear. I'm sorry, I was checking your last name again, Ms. from the AF.
Shelley.
Ms. Shelley. If we had an executive order that said that you have to affirm that you're not doing discriminatory boycotts internationally with any country or at all, that if it didn't specify a particular country, would you still have an issue with it?
A boycott is free speech.
Right. And so it doesn't matter.
And I believe, and we believe that regardless of what adjective you put in front of boycott, a boycott is free speech. And that's why, Delegate Hill, I use the example of hate speech, which is also protected speech because it is speech, even if we don't want to hear it, even if we disagree with it.
Right. So your argument is not specific to the order being about doing business with Israel. Your argument is that we should not be doing it to any business exercising their free speech.
Correct.
Okay, thank you.
I don't see any other questions. Thank you for being patient as we ask the questions, okay? Thank you so much. Next, we're going to call, I think, Mr. Ramadan. Okay. Rhonda Copperstein. Okay. Susan Karen.
Go ahead.
Yes, hi, how are you?
Good. I'm going to change a little because a lot of people already said what I wanted to say. My name is Susan Karen, and I lead Peace Action Montgomery, which is a local chapter of the country's largest grassroots peace network, and our chapter has 1,500 members. If you look at my written testimony, I've included a 2014 open letter that was written by Archbishop Desmond Tutu, who won the Nobel Peace Prize for his fight against apartheid in South Africa. He was also a champion of the boycott movement against Israel's apartheid policies. Archbishop Desmond Tutu wrote this letter in response to the Israeli lobby's efforts to push anti-BDS legislation across multiple states. The title of his letter is Maryland's Anti-Boycott Effort Designed to Punish and Intimidate. So he used us as the poster child for that because we had a real egregious hearing. The other two things I want to mention is today it came out that President Trump has considered the boycott of Tesla as illegal, and he has not criminalized that through an executive order. But if he took this piece of this executive order and used that, we would be the most hardest hit by that, and we wouldn't have a really good leg to stand on because precedent, we've done the same thing. And then the last thing I want to speak to is about this issue of apartheid. And as I said, Archbishop Desmond Tutu was a champion of the BDS movement, and so was Carter. But Omar Barghouti, who's the founder of the BDS movement, he's an Israeli Arab, and so he cares about what's going on in Gaza and in West Bank, but he cares about what's going on inside of Israel with the apartheid. And that's a huge population. It's 20% of the population. And it's larger than the African-American population in the United States, and they have a different set of laws. And in fact, there's groups called Masawa and Al-Dawa that are dealing with how they're discriminated inside Israel. So I just want to disavow that everything's fine inside of Israel, too. Thank you.
Thank you. Are there any questions for this witness? Seeing none, thank you so much. Let me call, because let me call one unfavorable to be balanced. Ms. Nicole Breedlove, are you here? Nicole Breedlove.
She was actually favorable but couldn't come. She made a mistake.
Okay. Okay. All right, so let's go to former Delegate Ali. How are you?
Hi, Delegate Penny Melnick. So I'd like to just talk a little bit about this issue. I boycott Saudi Arabia because I find some of their policies reprehensible. I boycott Russia. I boycott many countries. There was a time I was boycotting South Carolina because they had the Confederate emblem on their flag. All those boycotts did not prevent me from getting contracts with Maryland. I can boycott USA and get a contract with the state of Maryland. But if I boycott Israel, suddenly I get punished. Sued Larry Hogan, and in federal court, unfortunately I lost, not because of the constitutional issue. The federal court didn't rule on the constitutional issue. They said that I didn't have standing. But since then, since I filed that lawsuit, Senator Chris Van Hollen has come out very loudly, very solidly against this unconstitutional executive order, which singles out one country in the whole world that you can't boycott. Can you imagine that? Congressman Raskin has come out against this executive order. And this issue was taken up actually in the US Senate. Marco Rubio, when he was a senator, had a bill to do the same thing nationally at the federal government. And the Democrats, by and large, killed that bill, because they said, we don't support the BDS movement, but we also oppose laws and executive orders to punish the BDS movement. And I think that's the right position. Even if you don't support BDS, you should oppose laws that are unconstitutional and ban or punish people who engage in First Amendment practices. The last thing I will leave you with is, this country was built on boycotts. The Boston Tea Party was a boycott. There were many, many boycotts against England that led to the establishment of our nation. It's a quintessentially American political activity. Thank you.
Thank you for being here. It's great to see you. Are there any questions? All right, seeing none, thank you so much for being with us. Why don't I go ahead with Shelley? I can't see the last name, but it is Shelley Cohen-Fush. Good evening, how are you?
Good evening.
Good. Will you be so kind and give us your testimony?
Yes, of course. I am a local leader of Jewish Voice for Peace Action, representing the DC Metro chapter, which includes Montgomery and Prince George's counties. I'd like to respond to Delegate Rosenberg's questions a bit. As a Jewish American, I am one of many Jewish Marylanders, like JVP's 10,000 supporters in Maryland, who fully support BDS as a peaceful means of criticizing Israel's government, its oppression of Palestinians under apartheid law, its ongoing genocide of Gazans, and the way that it treats its own non-Jewish citizens, particularly Palestinians, inside Israel proper. Inside Israel proper, there are over 70 laws on the books that promote a fully Jim Crow segregated system. Yes, Palestinian citizens inside Israel proper can vote, but they are extremely discriminated against. I'd also like to respond about the issue of a discriminatory boycott versus boycott in general. This is not a discriminatory boycott. When we talk about discrimination, we're talking about people. We're talking about discrimination, in this case, that is considered anti-Semitic. This is not about anti-Semitism. It is about the value that we all hold as Americans under the Constitution to our free speech to criticize any government. That's what this boycott is about. Thank you.
Thank you for being here. I appreciate it. I noticed that there were a couple other people from the Jewish Voice for Peace that signed up. Was that just in case?
No,
because I don't see them virtually.
They couldn't stay this long. They had other issues they had to, and things that they had to address.
That was Ariana, Evelyn, and Nicole, and there's no one else virtually, right? Okay. Are there any questions for this witness? Okay, seeing none, thank you so much for being here. I appreciate you, okay? Is there anyone in the audience that did not get called for this bill? All right. Thank you very much for your patience. I really appreciate it. I hope you have a blessed evening, okay? Get some rest, all right? Because our night is long. Get some rest. And thank you for giving us the grace to, to be late, okay? Take care of you. This concludes the bill hearing on House Bill 1460. Let's go on to Delegate Metzgar. You've been waiting patiently. Thank you so much, sir. I really appreciate you. This is House Bill 1472, State Government State House Trust 10 Commandments Monument Display Act. And you have a virtual witness?
I think so.
Is Paul McAfee there? Will you bring him up, please? Thank you. All right. Thank you for being patient. Can you get started?
Yes, ma'am. Let me get my papers straightened out here.
Take your time.
I've shifted them around quite a bit.
Yeah. Okay.
Well, good evening.
Good evening.
Thank you, Madam Chair. I need to say this to you publicly. I look around here and I've been watching all day, and I've been in many committees this past year, and I will tell you, you run the tight ship. Every seat's been full. If not, they've come right back. So that speaks volumes to your leadership. So I tell you that up front.
Great colleagues, and they care very much.
You used to be a member of the committee.
I remember the tight ship. Right. Well, I would say good afternoon, but I'll say good evening, ladies and gentlemen. Madam Chair, Madam Vice Chair, distinguished members of the House of Government Operations. For the record, I'm Delegate Rick Metzger. Some will call me Slick Rick, but from Legislative District 6 in Baltimore County. Thank you for the opportunity. I just feel like I need to change the air from what we've been through this afternoon. I am the proud sponsor of House Bill 1472, which would place the Ten Commandments monument on the grounds of the State House. I'm a proud member, by the way, and the state chair of the National Association of Christian Legislators, and I wear the pin. I'm the state chair for Maryland. This past year, a couple of years I've been involved with it, but this past year, several people across this nation, there's about 16 states right now. There are several states, but let me get into this. But the Ten Commandments, by the way, the Ten Commandments are a moral foundation of the laws and the legal system of the United States of America, and permissible to be displayed on government property, which was upheld by the United States Supreme Court in 2005 and again in 2019. The Ten Commandments are on display right now at the Capitol buildings on the ground of Texas, Arkansas, Arizona, and Colorado, Missouri, and other public places, the courthouses, and schools around the country. Recognizing the historical role of the Ten Commandments accords with our nation's history and the faithful reflects of the understanding of the founders of our nation, with the respect and the necessity of civic morality to a functional self-government. History records that James Madison, the fourth president of the United States, stated that we have the whole future of a new nation under the capacity which ourselves to govern according to moral principles of the Ten Commandments. Think about that. The placement of the monument of the Ten Commandments on the grounds of the State House would help the people of the United States and the state of Maryland to know the Ten Commandments are as a moral foundation of the law. I need to share with this a quote from just a couple of the talking points that I wanted to share earlier before it got too late, and I know I still have several minutes of my time left. By the way, you have letters of support from the Maryland Catholics Conference and some others as well. But from the National Association of Christian Legislators, to whom it may concern, on behalf of the members and the supporters of the National Association of Christian Lawmakers across 50 states and Puerto Rico, I am writing to encourage you to vote for House Bill 1472, sponsored by Delegate Metzger and Delegate McComas. The Ten Commandments are important to the understanding and development of the written law around the world. Depictions of the Ten Commandments are on display outside the United States Supreme Court building in Washington, D.C. The Ten Commandments monuments are displayed on the state capitol grounds on Texas, Arkansas, Arizona, Missouri, and Colorado. The Ten Commandments monuments and posters are also displayed on various public grounds inside buildings around the United States. The National Association of Christian Lawmakers, the NACL, endorsed this legislation and authorizes the Ten Commandments posters on public grounds in 2024. I need to share with you also, ladies and gentlemen, the Ten Commandments were of paramount importance of the Jewish and Christian faith, and as today there was some people from the Muslim community that also supported this. The United States Supreme Court has insisted that the establishment and the clause must be interpreted in light of its genuine history and the traditions of our nation. The Ten Commandments are a source of Western and American law. By the way, from the first page to the last page of the 59-page document, which says, in the article, we have argued that the passive displays of the Ten Commandments in public schools are constitutional. Banning the display of Ten Commandments whose historic significance is unimaginable in Louisiana schools, because it also has religious significance, non-discrimination, and the First Amendment right, which we've heard tonight. Contrary to the claims to those who would scrub religion from the public square, there is no good reason to conclude that the text of the Ten Commandments utilized is sectarian. We have also demonstrated that the Ten Commandments is a source of Western and American law. Stone versus Graham no longer longer the good. Moreover, preventing passive displays of the Ten Commandments or other religious texts in public schools or state constitution against religion or violates anti-discrimination of the Constitution. Just a few things, ladies and gentlemen. As I mentioned, the courts of the United States and various states frequently cite the Ten Commandments. And again, in 2005 and 2019, and recognizing the historical role of the Ten Commandments according to our nation's history, faithfully reflects an understanding of the founders of our nation with respect to the necessity. So therefore, when I speak of this, I am speaking from the heart because I know that everyone in this room has watched the movie Ten Commandments. Let me see if you've seen well, this is quiet. So I've asked you for a favorable, and if you don't co-sponsor this one, I'm going to pray you don't sleep a wink. God bless you, ladies and gentlemen. I truly believe you will support this. This is a good common sense. And by the way, the physical note says it's $4,000, but I will tell you that every dime for the Ten Commandments to displayed on these grounds will not cost a taxpayer a dime because it's privately funded throughout the country. God bless you.
Let me open it up for questions, Delegate.
Yes,
and thank you for the compliment. The committee is very, very, very committed. Good people. Are there any questions for the delegate? All right. Seeing none, Delegate, thank you for being patient. We do have someone virtually, correct, for this witness? Okay, can you bring them up? Good evening. Is Paul? Hi, how are you?
Good, ma'am. Madam Speaker, thank you very much for letting me testify by video here.
Thank you. Go ahead. You can get started.
All right. Good evening, Madam Chair and members of the committee. My name is Paul McCosby, and I'm an attorney working with the Maryland Family Institute. I'm testifying today in support of the proposal to provide for the placement of a monument of the Ten Commandments on the grounds of the Maryland State House. This is an excellent idea, fully consistent with the traditional practices of the state and nation, as a memorial of the permanent legal and moral precepts which have shaped this country. It's precisely this reasoning that is expressed by the Supreme Court in 2005, when the court's opinion stated that acknowledgments of the role played by the Ten Commandments in our nation's heritage are common throughout America. We need only look within our own courtroom. Since 1935, Moses has stood holding two tablets that reveal portions of the Ten Commandments written in Hebrew, among other lawgivers in the South Frieze. Representations of the Ten Commandments adorn the metal gates lining the north and south sides of the courtroom, as well as the doors leading into the courtroom. Moses also sits on the exterior east facade of the building, holding the Ten Commandments tablets. And that's from the court's opinion in Van Norden v. Perry. There are already numerous memorials, plaques, and pieces of statuary all around the State House and its grounds, as you are well aware, including a memorial to the women's rights movement, the USS Maryland, and the Lithuanian Society. This proposed Ten Commandments memorial would be a valuable addition to the artistic and cultural wealth of Maryland's capital. The Mosaic Decalogue has stood for millennia as an expression of justice and moral wisdom, valuable to the state's cultural enrichment and to the affirmation of the timeless principles of law and justice. Therefore, I ask that this committee return a favorable recommendation. Thank you.
Thank you so much, and thank you for being patient, okay? We're going to open it up for questions, see if there are any for you. Are there any questions for this witness? Thank you so much. We really appreciate you, and I hope you have a blessed evening.
Madam Chair, I just want to leave you with this. All Rick Metzger wants to be is a servant in the vineyard. God bless you.
Amen. God bless you as well. Have a blessed evening, Delegate. This concludes the bill hearing on House Bill 1472. Let's go to Delegate Chris.
House Bill 1351, Health Insurance Provider Panel Credentialing for Behavioral Health Care Professionals. Thank you for waiting as well, okay?
Oh, thank you.
Appreciate your patience. Everyone that's waiting, thank you very much.
And I will echo the sentiments of Delegate Metzger. I love you guys too. Y'all are amazing.
Thank you.
And I know it's getting late, so I'll be as brief as I can, but I certainly don't want to leave anything on the table either, because this is a very, very important issue. And before I talk about House Bill 1351, I just want to thank the committee. Back in 2019, you guys passed a bill, and a year later passed another bill that's very related to this, and it had to do with the provider panels for mental and behavioral health, and nudging the health insurance provider panels to expedite the credentialing process. And it has helped. And the work that the committee did back then, it made a difference. But we're here again, and I think if I can make any statement where we can all agree, is that if someone needs mental or behavioral health treatment, they should get it. They need to get it because of the social consequences if they don't get it, right? And that's a regardless, even if regardless of their ability to pay. We need to make sure that every single person who needs treatment, they're getting it. And I also too, that being said, we you know, whether it's a private provider or a nonprofit provider, we don't want anyone on waiting lists. We don't want, you know, anybody being turned away. And there are two challenges. One is we just don't have enough providers. And there's a lot of things we can do, certainly, to recruit. And hopefully young people get into the industry and be interested in becoming a therapist or a psychologist. But the other piece now is we almost can't get out of our own way. The second piece is where, you know, we have private providers. And I have Beth Ann Dorman, she's executive director for All Seasons. They don't have a waiting list, thank God. And they don't turn anybody away, thank goodness. But there are a lot of providers who are. And the worst cases, they're turning people away who have health insurance. And that's sad. They shouldn't be, you know. And, you know, my family needed, you know, treatment. Not that long, well, it was about 10 years ago. And I was a state delegate at the time. You know, I had Blue Cross and Blue Shield, just same insurance that many of you guys have. And I'm like, you know what, we should be able to get service somewhere. And there were so many providers out there that just wouldn't take us because we had health insurance and we had Blue Cross and Blue Shield. And we were astonished. Didn't know why. The provider panels was part of the problem, that initial credentialing process. But the challenge that we have now, though, is that once they, and they being, these are folks who have gone to graduate school. These are folks who have gotten all the training necessary to provide the service that we need them to provide. And they went through the licensure process by the state. So the state approved these licensed graduate social workers to provide a service. And they have also gone through a rigorous national program in order to be able to get credentialed. And this is a situation where the federal government through Medicaid is actually doing a much better job than the private sector is. And that's a shame because right now those folks that they're turning away because these licensed graduates aren't credentialed, they're turning them away because the private health insurance providers are taking almost a year to credential them. And right now, Medicaid's about 30 days. And so what this bill does is it aligns a requirement for our health insurance companies to basically fall in line with what Medicaid's been able to do. Because if Medicaid can do it, I don't see any reason whatsoever why our health insurance companies can't credential these licensed graduates during the same time period as the process to go through the Medicaid. So that's my testimony. I'm certainly happy to answer any questions. But I do have Beth Ann on my panel as well, so I don't know if you want to hear her testimony before we take questions.
We can open it up for questions, okay?
Thank you.
Thank you so much, Madam Chair and members of the committee. Here's the bottom line, folks. We're here. My name is Beth Ann Dorman. I'm the president and CEO of For All Seasons. We're the largest behavioral health and rape crisis center serving not only the 5 counties of the Midshore, but the entire state of Maryland. Here's what I want to say to all of you. Mental health is important. We're in a crisis right now, and we have a situation where we have created an opportunity for folks to receive services. If they have Medicaid, in 30 days, that we can credential our clinicians who are master's level licensed clinicians by the state of Maryland. We can back bill. If someone comes in our doors who has private insurance, it's taking up to 180 days to credential our master's level Maryland licensed clinicians. We cannot back bill for services. We cannot see folks. So our agency has heard loud and clear when the state has said, be more effective, be more efficient. It took us 2 years to completely revamp our services. We have no wait list. We serve all 24 jurisdictions of the state of Maryland. Every single one of you in this room has constituents that are being served by our agency and agencies like ours across the state. So when someone walks in with Medicaid, they can be seen immediately. If someone walks through our doors and they have private insurance, we are told by the private insurance companies, we will let you know whether or not we can credential your licensed clinicians by the state of Maryland within 120 days, but it is up to them whether or not that process happens. I'm here today to ask you to please support House Bill 1351. We have to change the way that we are allowing folks to be delivering services in the state of Maryland. Because here's the choice. We delay care, forcing people to wait who are in crisis, or our agency provides this service and cannot bill for the service that we are providing. There is a financial impact, and there's also a safety risk if nothing changes. Thank you.
Okay, I'm going to open it up for questions, and then I have a few unless they ask them. I saw Delegate Kipke first, then Hutchinson.
Thank you. Madam Chair, it's strange, some of these issues that we've heard many times, I thought this was solved, and here it sounds like it's a big problem still. In the past, I've heard people say that by speeding this up, it provides a risk to public safety. You know, it rushes along the process. I mean, obviously they're doing it in Medicaid, so I don't necessarily buy that, but I do see that as some of the opposition. So I'd like you to talk about that. And you were finishing your comments as it relates to the financial issue that this creates. Could you help us who don't do what you do better understand what that problem is? Thank you.
Sure, absolutely. So let me first start with the pre-credentialing vetting process that happens. When a master's level clinician graduates from graduate school, there's two levels. There's licensed master social worker and there's licensed graduate professional counselor. That means that you've gone through your master's degree, you've passed the state licensure exam either through the Department of Social Work or through professional counselors. As an agency and across the state of Maryland, we then have to secure an NPI number. That's the National Provider Identification Number. We have to, as an agency, submit the professional licensure status, educational credentials, and personal identifying information. Once that has happened, the Centers for Medicaid and Medicare oversees this process, ensuring that only legitimate providers receive the identifier. After the identifier is received, they then go to the CAQH, and they being us as an agency. We have to submit the licensure verification, the education history and training details, the work history and references, the malpractice insurance documentation, and submit a criminal background documentation disclosure. Once CAQH has been worked through, then we need to go through an independent background check by our employers. So state and federal criminal background screenings, verification of professional licenses and certifications, a drug screening where required, and reference checks and past employment verification. One of the things that we know from our private insurance companies is that the delay is being spoken about in that they still need to be able to verify that the clinicians that are trying to credential through their process are okay to see clients, that there's a background check, that they need to verify their credentials. What I'm saying to the committee today, and in response to your question, is if we have to go through all of this, if the state of Maryland has said that they are a viable candidate to be able to deliver services, if Jeff walks through my doors today and I can see him if he has Medicaid, but I can't see him if he has Care First or United Healthcare or Aetna or Cigna, there isn't a common sense methodology behind how we are credentialing our mental health professionals. As far as the financial burden that it places on agencies, If I hire a clinician tomorrow at $35 an hour, baseline, master's level clinician, first out of graduate school, again, licensed, eligible to see Medicaid and be able to back bill, we're talking about 180 days. While providers are saying it takes an average of 120, the reality is what we're facing is 180 days. So you're talking about $35 an hour for a 40-hour work week for clinicians that we are paying, keeping on our payroll, but we cannot bill for services. So when you work that through for that 120-day credentialing process, that's $24,000 that our agency is having to put out with clients that are unable to be seen. When you talk about the loss reimbursement, we know that in every 5 business days, we can do 2 new client intakes. We can see 4 family therapy sessions, 24 standard therapy sessions. When you look at 120-day delay, 24 5-day periods means 48 missed new client intakes, means 96 missed family therapy sessions, and 576 missed standard therapy sessions. So you're talking about a total of 750 missed services, which equates to $78,000 in missed reimbursement for agencies who have the staff in place to see the clients who need services.
Thank you. I appreciate your passion. Just a really quick question with a really quick answer, please. After that you wait the 180 days, do any of them ever get rejected?
We see an average of 15% of our folks being rejected, but I will remind the committee that the 180 days that we're waiting, we can't back bill for the clients that are coming through our door. So we're sitting ducks until that approval has been given.
They can still reject within 30 days, though, if we limit. We just want to push them to do it quicker.
Yeah, the rejection is absolutely a possibility, but if we've gone through all of those other processes that I explained, most times we are able to push people through.
I just want to add something to what she was saying, too. For All Seasons, they're nonprofit. So when they have to carry those salaries and they have to carry that payroll, even though they're not getting reimbursed, they have to go out into the community and fundraise in order to be able to still pay their bills. I just want to make sure that we add that. And they're not the only nonprofit agency in the state that's going through this. I bet if we do a survey, 100% of them will share the same testimony that Beth Ann is today.
All right. I have a couple more questions. Delegate Hutchinson, followed by Vice Chair Collison.
Thank you, Madam Chair. I think Delegate Kipke answered or asked one of the questions I had in my mind. But Ms. Dorman, you obviously serve my district and you're my constituent. And I did miss the opening statement by Delegate Grice, but give me a magnitude of what this is doing in terms of impeding behavioral health services in the Eastern Shore.
It means that we have folks that are walking through the door, and if they are insured by private carriers, we are not able to say, yes, come walk through the door and be seen today. We are not able to see the 2 intakes a week that we would normally do, the 24 sessions that we would normally do, because the choice for our agency is take folks in, see them on a weekly basis and not be able to bill, hold all of the cost, or wait the 120 to 180 days when we can receive reimbursement. And that's across the board. This is not just our agency. These are all agencies that are waiting through this process. And when Medicaid has this process of 30 days, and the other piece that really impacts the Eastern Shore is we're already in a shortage. So we've worked as an agency, and my sister agencies across the region have worked to change our process. We've created very good programs where we are using interns from master's level programs. We're able to hire them. So talk about recruitment and retention. We've solved that problem. Talk about eliminating wait lists. We've solved that problem. The problem now is when we get folks in our door, we can't serve them because they hold private insurance. And so we have family members who are saying, you're telling me I am a working member of the community. I have a good job, I have health insurance. If I had Medicaid, you could see my child today, but I have private insurance, so you can't see me for 5 months.
Unbelievable. Thank you.
Chair Collison.
Thank you, Madam Chair. Couple of things. So I think I heard you say that you do all of the background checks.
We do.
And do you then send those to the carriers in the application?
Yes.
So carriers get that up front. And would this bill apply only to like an agency like yours or to individuals who, or to individuals who are seeking to become part of a network?
So we have a contract with these private insurance companies that allows us to be able, as an outpatient mental health clinic, as do my sister agencies, be able to submit to the private insurance companies. We are not lobbying for anyone in the world to be able to hang up a shingle. This is talking about agencies that are already in contract with professionals who are working with the providers and the healthcare side of insurance, where we've established this. So the background check has already been approved because you wouldn't get an MPI number without it. You wouldn't be able to go through CAQH without it. All of the steps that the private insurance companies are asking us for, we've completed those, and we are recognized as outpatient mental health clinics and in contract already with these private insurance providers.
Okay, thank you.
Thank you.
Delegate Olson.
Sorry, and if you have answered this, I truly apologize, and thank you, Madam Chair. Do you know why it's taking so long?
So what we are being told is that there is an arduous process that the insurance companies need to go through. They need to verify the credentials. They need to verify that the license is valid. All of the things that we are already doing. In the state of Maine, they've already passed it to be a 60-day process. And what we are seeing across the country is that best legislative practice is between 30 and 45 days, 30 for practitioners, 45 days for specialists. And I will say that there has been an unfavorable memo put in through testimony that talks about this would subsect out the mental health community from other practitioners. And my question is, okay, so then let's make some changes. Just because it's always been the way that it's been doesn't mean it's the right way when we are in the middle of a mental health crisis in our communities, in our state, and across our country.
And to be clear, these people are already cleared through CMS.
They are,
Okay,
correct.
Thank you.
Thank you, Madam Chair, and thank you, Delegate Grist, for this bill. 2 questions. Do you know what the most common reason is that the 15% of your providers who apply, complete the application, are later rejected?
I do not know, but I can get you that information. Sure.
That would be really
Yes.
helpful. And let me ask you this, since this is, may I have a follow-up, please? I had started off with 2 questions and you didn't catch me. Thank you. Would it work if, since they're already certified to go and they're licensed and all that kind of stuff, if we said that if a person, from the time that they've completed the application until they're accepted, that if they're accepted onto the panel, they're obligated to pay any back bills?
That would be lovely.
All right,
That would
thank
be
you.
lovely.
I see another question. Delegate, your bill is not cross?
Correct.
Okay. Was there a reason why you didn't cross it?
Well, the last time we had a credentialing bill, I had a hard, I know this is, we're going to blame the senators, but the senator's not around anymore, but I had a hard time. In fact, it was very heavily amended. I don't know if you remember that or not. And
I remember
there was a
it.
major struggle to get.
We got it through, though.
We did. We got it very, and it was very, at the very end of session. And so the senator, I asked them to withdraw the bill. So even in that situation, we just crossed it over.
Okay.
So,
All right,
yeah,
I was just curious. So I'll do something that I've done a few times here. I do like the bill, and I think it's the right thing to do. I know that the carriers put in a letter, of course, favorable in opposition. I like that 60-day. So if I can give you a little homework, can you look at other states and see how many days they are?
Sure. Absolutely.
And then I like to ask Vice Chair Collison and Nick, Delegate Kipke and Hutchinson, if you guys can meet with Matt Centilano and Olson.
So we can just pass it.
We want to make sure that it passes the Senate, all right?
I appreciate that.
Because we pass it here and then they go to the other house, and we want to make sure they keep their word. So Alston, Hutchinson, Kipke, and Collison, if you could work with the sponsor and with the carriers and tell them that we want to pass it, and send it to subcommittee. Absolutely. Feel free to join, Delegate Woods. All right.
Thank you, Madam Chair.
I see there were two other people here. One second, where is it? Robin Elliott, I don't see Robin, and she was in favor, and Paul Ellington was also in favor. Paul Ellington's here? Would you like to come, Paul?
No, I'm fine. He wants to quit while we're ahead.
You want to do a Me Too, Paul? Okay, Paul is a Me Too. This actually concludes the bill hearing on House Bill 1351. Thank you for waiting, okay?
Thank you so much. And I just want to say to all of you, this really, it means a lot. It means a lot to the people that you serve. And I just really appreciate the fact that you've been here tonight and waited out and been so engaged in hearing and listening to the responses, because this is about saving human lives. So thank you.
And thank you for your passion. We appreciate it and your leadership. All right, so let's move on to now Delegate Kaiser, House Bill 1474. It has 3 witnesses. Then Delegate Riley has 4 witnesses. And then we're going to go to Acevedo with 11 witnesses. And Arakan with 20. I don't know if they're all here, but let's do it that way. So Delegate Kaiser, will you come out with your panel? Please, Delegate Riley, if you could be ready afterwards. And then Acevedo will go after that, okay? So let's call House Bill 1474, licensed professional counselors, telehealth, students enrolled in institutions of higher education. Delegate Kaiser.
Thank you, Madam Chair. Thank you to members of the committee. This will fortunately be shorter than some of the other bill hearings today. This is a high bill number. It's one of those things that happens when you turn your bills in Thursday morning. A few of them get in the 11 and 1200s, and then some get in the 1400s, even though you turn them in together. And then here we are the last week before crossover.
Note.
What's that?
I saw something amazing in your fiscal note.
Well, I'm grateful for that. So let me tell you, in terms of the telehealth, I mean, you all know that I teach, and that is not where this idea came from about focusing telehealth on our students that come here from other states. It really, kind of a funny but fond memory for me. During the pandemic, and surveying, all of us as members were having meetings, obviously not in person or anything else. And it was around the Christmas break time that year at the end of 2021. I don't even remember now. And I was having a Zoom meeting with a member of the Organization for Psychologists in the state. And I was on the couch in my in-laws' bedroom, because that's what you have to do. You're like half paying attention to your child and having to have meetings with people on some interesting issues. And it was described to me at the time that one of the things that we could do with telehealth was having people having their telehealth appointments across state lines. And it was one of those things that came out of the pandemic. And obviously, loss of life and so many other awful things happen. But in my mind, as a policy person, as we all are, seeing how telehealth kind of expanded at that time in ways that it always should have. And so from that sense, I always remember that meeting with Dr. Savage that I think has testified before this committee multiple times, and that's who I met with at the time. I mentioned to some people a few years ago, I had telehealth for physical therapy, sitting down on my floor with my laptop so the physical therapist could see what I was doing. I mean, telehealth, to me, this was like one of the great things that came from it. So this is a longer story than I usually tell. So I just say that to say that's where the fascination comes in. The thing is, when the pandemic ended, we started peeling away from some of the telehealth that we were doing. And we passed a great bill earlier this year, I believe it was yours, Madam Chair, that's dealing with telehealth and coverage for it and in-state. And so we still have a challenge with out-of-state, and we need other states to agree. Now, this bill was focused on licensed professional counselors. The psychologists already have a compact. In this case, looking at the licensed professional counselors was a chance to say, people should be able to continue. The challenge is that we can't tell other states to do this for our students that attend their colleges. So the least we can do is help the people who are here. And we put some provisions in the bill. We limited the number that you had to have a prior therapeutic relationship. And you could have only a limited number of appointments in a given month or in a given year. And so those were some of the main provisions. Now there is a counseling compact that's coming down the proverbial pike. but I believe it's going to be piloted with just 3 states, and we're not one of them. And even if we were, most of the other states where our students are going from this state aren't necessarily in those other couple states. And it's also true that even as a compact happens and hopefully does expand over the next few years and hopefully includes all states at some point, there will still be a number of years where we will be in a compact, hopefully with 10 states, 15, 20, 25, but still we'll have students that are attending colleges elsewhere that are your kids and our other residents' kids who can't continue that coverage. So that was the impetus for all of this. Certainly looking at some amendments, and I have sets of amendments that we will offer to the subcommittee in terms of the number of days and whether we want to expand this beyond licensed professional counselors. Glad to have Andrea Mansfield here, who represents the licensed professional counselors. I think the board has a different opinion, but they don't take action on legislation pretty quickly. They're not on our timeline. But I mean, I just think it's important that we continue with this, thinking of it as limited licensure exceptions. And that I think we have an opportunity here, and I apologize, in terms of the amendment, we could create a 1-year continuity of care exception for everyone. So have some amendments if people are interested. But, the goal, hopefully long-term, is that this is true for everyone around the country, that they can have this type of continuity of care, whether they're a student, whether they're a spouse, whether they're on a long-term trip, vacation, or something else. Why shouldn't they be able to easily see their care provider when they're here in the state of Maryland? So, thank you, Madam Chair.
Aside for a short meeting, I want you to think about, if you can answer after Ms. Mansfield testifies, why 1 year is so long, why not 6 months? But in any event,
we were actually looking at 4 years, so 6 months would be, okay.
Good evening.
Okay, thank you, Madam Chair, Madam Vice Chair, members of the committee. Andrea Mansfield, here this evening representing the licensed clinical professional counselors of Maryland. And actually, I don't think we could have had a better bill to be heard before we had this discussion here, because really this bill is also about providing that continuity of care, ensuring individuals have access to mental health providers to help them get through a crisis should they need it, which is why when my client looked at the legislation, the bill is introduced is focused on students in higher education institutions, but really they looked at it much broader than that, saying this is about really continuity of care for a client, not just students, but any individual that would be coming into the state of Maryland. They are having some sort of a mental health crisis. They've been seeing a counselor in another state, and they want to ensure that they still have that access to get them through that situation, because they would say, God forbid, somebody comes here and has a horrible circumstance and there's a horrible result from that. So they really do see this as a much broader issue in providing that continuity of care. They have been having conversations with some of the board members. They have actually had conversations with the Counseling Compact individuals. They have been talking with other states, Virginia, Delaware, Pennsylvania, and North Carolina. The amendments that we have proposed to the sponsor are mirroring the state of Virginia. And what those would do would allow, so a licensed professional counselor from another state, if they would allow that out-of-state counselor who is in good standing in the other state with a previous established therapeutic relationship to continue providing that clinical professional counseling service for no more than 1 year. And that is mirroring the Virginia language. And we would be willing to have conversations if there's another time frame that is more workable for that. But I know my client really believes this is an important issue. Providing that continuity of care is very important. So they've been working really hard trying to find the right, approach to do that. So with that, we were very supportive of the legislation and urge a favorable report with amendments. Thank you.
Perfect. Andrea, you signed up with amendment, so remind me what the amendment was if I missed it.
Yep. Yeah. So the amendments in the written testimony, they're actually in the back. So it's amending a different section of the statute that deals specifically with licensed professional counselors, and it would allow individuals from another state that are in good standing I'm trying to sell. I got to put these glasses on because I can't see this print. Basically, they are in good standing to continue the practice for the purpose of providing continuity of care through the use of telehealth or telemedicine services as defined in the title. And the licensed counselor has a previously established client-counselor relationship with that client. And it would allow those services to continue for up to 1 year in those circumstances.
Okay, great, thank you. Questions for, oh, actually, Mr. Ellington, did you want to join this panel? You're still a me too? Okay. We like your testimony, thank you. Questions?
Best testimony of the night.
Absolutely. Questions for the sponsor or her panel? We're going to go with Delegate Taveras and then Delegate Hill.
Thank you. As a customer, due to the Parity Act, I wouldn't think that somebody who would see a client or a student for 15 days in a year, I don't know how enough that would be. So I would be concerned about that, given that students in school, who is this? Students in school tend, like 15% of them tend to fall into depression.
If you hear from my students, possibly higher. Delegate Taveras, it was the balance. It's somewhat related to what the chair already said. Why not 6 months? And I heard that loud and clear. I guess the point I would say is we were trying to find a low enough number to not make people think that we were taking over and not getting rid of possible business for people here, but really trying to say we're trying to continue this therapeutic relationship. And like so many other decisions that we have to make is that balance between what gives that continuity of care, but it doesn't, I guess, get in the way of what we think we should be doing when someone is here long-term. So.
Okay.
It could be less, it could be more. So.
Okay. Delegate Hill.
Thank you, Madam Chair. I tried not to ask, but you took me there. So the board says this is not a matter of competition and taking business away. They say this is about safety. And I would like to hear your answer. I love this bill, by the way. I think it's well and long overdue and it's not broad enough, but so it's clear where I stand.
Thank you, Delegate Hill, and thank you for giving me the opportunity to address this. The concern that they have is somebody has a kid, they go off to college, let's say we had this compact in the future or something, and they seek, let me just tell the story differently. Let me back up. Let's say we pass this, and there's a student from some other state, and they're here in Maryland, and they're here as a student, and they're seeing their counselor from their home state, and their counselor from their home state does something wrong professionally, whatever that might be. And then there's a concern that there might be a liability on Maryland and that there's a licensing issue for Maryland and the doctors. And I just don't buy that argument. I don't think, does that mean there aren't bad counselors, doctors, therapists everywhere across the country? Sure, there are always some small amount. But I also know that this wasn't really a problem during the years of the pandemic where we were doing this between states. And if the counselor is licensed and in good standing in their own state, I'm not sure what more we can ask for. So I understand their concern, but I think it's heavily outweighed by the other side of someone losing their continuity of care and what that means. And I think for anyone who has had care, knowing how hard it is to find a therapist or counselor that you trust, that you believe in, and all the rest, and then that, I think, is a bigger safety issue.
Thank you.
Thank you, Delegate.
Delegate, that's Gazzoni, right? Your light is on? Okay. I was trying to figure out which mic it was. So Delegate Gazzoni.
I feel like I need to move around. Thank you, Madam Chair.
Are other states doing this? It sounds like Virginia maybe, and I just want to be curious about that. And I will also say that I have a niece who lives in Montana, is currently in school in Arizona, and this would be super, super, super helpful for her. So just saying, this is something that I think
I'm looking at some great data that my office produced, some, in Colorado, 20 days, 120 in Connecticut. Illinois is part of the model of what we looked at, 45 days in Utah, a year in Virginia. And then I think, the list goes on, and I can share this with you, but other states are doing some version of this, and I think we should be doing the same thing.
Just toss it out there, 6 months, 12 visits.
So moved.
Okay, Delegate Woods.
Thank you, Madam Chair. So I guess my question is, aren't there supervision protocols in place that would help to assure that the therapist is providing the appropriate care?
Can you repeat the question? I'm sorry.
My question was, aren't there, when you talk about the therapist, aren't there supervision protocols in place that would help to assure that that licensed professional counselor is on track? Do they not have what most of your counselors have who are not clinical technically, that they have a clinical supervisor in place?
Please.
My understanding, Delegate, is that, unless you're actually licensed in the state, you're not able to come in and practice in the state. So, which is why I think this is important for that purpose. So they wouldn't, I don't think there would be a supervisory relationship in that case necessarily.
May I?
Unless
I'm sorry. My apologies. May I follow up?
Yeah.
So this is what I don't understand. That even though they're not in that state, don't they still have to fall under supervision in the state that they're in?
Oh, correct. I'm sorry, I misunderstood. Yes, and in the bill, they would need to be licensed and in good standing in the state where they are licensed to practice. So,
and
yes,
they would be under the supervision of a higher level licensed clinical professional counselor, correct?
They would be they would have a board in their state that oversees them, if that's what you mean.
That's what I'm saying.
And so if that maybe also addresses what Delegate Hill was asking about in terms of that safety issue, that yes, they are still being licensed and overseen.
Right, so there should be protocols in place is what I'm saying that help to kind of protect that, right, the service.
Yes. Yeah,
that's what I'm saying.
Yes.
Thank you, Madam Chair.
Okay. Seeing no further questions, that concludes the hearing on House Bill 1474. Thank you, Delegate Kaiser.
Thank you, Madam Chair.
And we will go to House Bill 1355, Delegate Riley. And if you want to bring up Michael Canary and Anthony Hagedorn, who have great endurance and persistence.
Madam Chair, I do believe the three that are here with amendment. So I don't know if you want them. Well, that's okay. They're already
sure.
Here, I can scoot over. You guys need.
Well, we'll ask you questions before we let them go. So, Delegate Riley.
So good evening, Madam Chair and esteemed members of Health and Government Operations Committee. For the record, I'm Delegate Teresa Riley here from District 35A, here to introduce HB 1355, Health Insurance Required Coverage Hearing Aids. During the 2024 session, we passed a bill requiring certain carriers on the Maryland Healthcare Exchange to cover medically appropriate and necessary hearing aids for adults, if prescribed, fitted, and dispensed by a licensed audiologist. HB 1355 will improve access under the same requirements of the covered adults' hearing aids, so only adults. That's important. If the hearing aid is ordered, fitted, and dispensed by a licensed hearing aid dispenser. So that's the main portion of the bill. We are adding, it already was passed for licensed audiologists. Now we're adding licensed hearing aid dispensers. So that's basically what the bill does. A licensed hearing aid dispenser means a hearing aid dispenser who is licensed by a state board of examiners to practice hearing aid dispensing. There is an amendment that is going to be suggested by my wonderful panel here, but I do want to mention, it does have some history. I believe the amendment that is in our testimony, there's 3 of them that mention the same amendment, I believe. And that amendment was addressed in the Senate version, and it was considered, and the Senate Finance Committee, their counsel, and the Board of Audiologists suggested that it was not necessary. So I will leave that up to our counsel over here on the House side to see if you think it's necessary, but that was their opinion. So the bill, the House bill, this is a cross-file to Senate Bill 641, which was amended to look exactly like my bill. So they dropped it really early before we put the amendments. So the bill that you're looking at, the House bill, is the actual bill, and that particular bill passed identical to this one in the House committee already to date. So I respectfully ask for a favorable report, and I'm happy to answer any questions at this time.
Thank you, Delegate. Questions for the sponsor? Seeing none, but I have a question. So I'm assuming, in which case I think we need to clarify, because I have to assume that the licensed hearing aid dispenser would have gotten a prescription from an audiologist.
Correct. So that's why it says
ordered and not in the
and not prescribed. Yes.
Okay.
So that's, I think, what they say is
That's
clear enough
clarifying enough?
language, and so that's.
So there won't be any confusion over
Correct.
that issue. Okay.
But then they will testify. And
Great. Okay, thank you. Seeing no other questions, we'll go to the favorable amendment with amendments, and whoever wants to go first.
Good afternoon, I was going to say, but it's good evening. My name is Anthony David Hagedorn. I'm a second-generation hearing aid dispenser and small business owner, and I became licensed to fit hearing aids in Maryland in 1978. I come in support of House Bill 1355. A little history. In August of 2022, the FDA added OTC hearing aids as a new class. At the same time, the traditional hearing aids that were being fitted by both audiologists and hearing aid dispensers were reclassified from restricted medical devices to prescription medical devices. The FDA limited the dispensing of non-OTC hearing aids upon the prescription or order of a practitioner licensed by law to direct the use of such device. Shortly after, to clear up some confusion, the FDA sent out a letter to the states clarifying that all dispensers, both audiologists and hearing aid dispensers, who were fitting hearing aids prior to the new OTC class would still be able to recommend, select, and fit prescription hearing aids. Under the new FDA terminology, the terms prescribe and order have the same effect and meaning as far as the FDA is concerned. In 2023, Maryland changed its statute to ensure that the audiologists and hearing aid dispensers both have the authority to order the use of prescription hearing aids so consumers could continue to have the access they always did in the past. In 2024, Maryland signed into law a bill mandating health plans to provide hearing aid benefits, but only the audiologists were specifically listed as able to order and dispense for purposes of coverage of the law. Hearing aid dispensers were left out. HB 1355 seeks to correct this omission of hearing aid dispensers and reflect the updated language with respect to the terms prescribe and order having the same meaning. Thank you for giving us the opportunity to testify.
Thank you, and thank you for staying this all day. Mr. Canary.
Good evening, Madam Vice Chair and members of the committee. My name is Mike Canary, and I'm a second-generation hearing aid specialist with an office right here in Annapolis. I speak in support of this bill. I would like to go to an issue that you brought up, Madam Vice Chair, earlier. One of the most important things for us as hearing aid specialists is to try to make sure that there is clarity about the new language of the FDA. The idea that hearing aid specialists would have to receive a prescription from an audiologist to fit hearing aids would severely limit our practice and the work that we've been doing under our license for many years. That was not actually the intent of the FDA. And in fact, when the Maryland Academy of Audiology wrote a letter of support for this bill, they made this very clear. I'm going to quote from their letter. This is from the Maryland Academy of Audiology from February 26, 2025. They say the change in semantic language from prescribed to order mimics the health occupation statute language and will confirm that hearing aid dispensers can order, fit, sell, and dispense prescription hearing aids without any barrier of a prescription. Okay. So even the Maryland Academy of Audiology recognizes that the new language of the FDA implies that the word order and prescribe are used in the same way as it relates to prescription hearing aids. Okay. So the language in this bill is clear and deliberate and harmonizes perfectly with the FDA regulations, federal statutes, and Maryland licensing laws. Our biggest concern now is to be sure insurance providers are not confused by any of this new language when making policy. Language that hearing aids can be prescribed or ordered by a licensed professional will ensure that people continue to have the choice of providers they've always expected. Okay.
Okay, thank you. Questions for this panel? So I do need clarification then. So and I honestly don't know the answer. Do hearing aid dispensers, are they licensed to do audiological tests?
As a part of their scope of practice, they do very specific audiological tests. Yes. Audiometric testing of air, bone, speech that are required to properly evaluate a person's hearing and then fit hearing aids to a person.
And that's current practice in Maryland?
Yes, ma'am.
Okay.
There's some confusion about the professions of audiology and hearing aid dispensing. One of the best ways to understand this is that the audiologists have a much broader scope of practice, of which hearing aid dispensing is one subset. Hearing aid dispensers have a very narrow scope of practice entirely related to hearing aid dispensing. And so people like myself and Tony and others around the state have been credentialed by all of the major insurance companies for years to be able to provide hearing care to patients with insurance for hearing aids. Okay. And it would be a shame if in trying to expand the care, we wound up limiting care and restricting access by cutting out one of the major professions that fits hearing aids.
Yeah. Thank you very much. That's really helpful. Seeing no other lights, that concludes the hearing. Thank you very much, Delegate, for bringing us this bill.
Thank you.
That concludes the hearing on 1355. We will now go to House Bill 1473, Delegate Acevero. And Delegate, if you would bring up any of your panel members who are here.
They've all gone home.
Have they all gone home? Seriously? Just you?
Me.
They're
just me.
Leaving you here by your lonesome, but welcome back to the council.
And Connie. Connie.
All right.
Of course. I was absolutely. Give it up for Connie.
A real trooper.
A real trooper.
Okay, so this is state government equal access to public services for individuals with limited English proficiency and individuals with disabilities. Delegate, please proceed.
Thank you, Madam Vice Chair and members of the committee. I will be very brief with my testimony because the bill is a reintroduction But House Bill 1473 essentially seeks to squarely address the issue of a lack of language access for limited English proficiency individuals and individuals with disabilities. By expanding the current Maryland language access provisions of our public state agencies, we will be able to provide accommodations that include bilingual staffing, staff interpreters, telephone interpreter programs, oral translation, and written translation for critical services that allows us to better serve the 19% of Marylanders that speak foreign languages. These services seek to provide equal access to public services for all, regardless of their primary spoken language, and includes all of our constituents. The importance of the lack of language access has become even more pressing recently due to the Trump administration rescinding the 25-year Executive Order 13166, which required federal agencies to provide language assistance services to LEP individuals. There is now no requirement for federal agencies to do such, and so we do not see the kind of linguistically inclusive policies that we've seen in previous administration. And so this bill is attempting to not just correct that, but to also serve our constituents by improving the lives of Marylanders who up to now have continuously struggled to engage with state agencies in a non-English language. It will establish access to state agencies for limited English proficiency individuals when access at the federal level has been rescinded. Therefore, I urge a favorable report on 1473 to expand language access for all Marylanders. And I appreciate your time and attention and just sticking it out this late to not just hear folks who came here to testify, not just on this bill, but other bills. And thank you so much, and I urge a favorable report.
Thank you, Delegate. Yes, please, go ahead.
Good evening. Madam Chair, Vice Chair, my name is Cornelia Bright Gordon. I'm here with Maryland Legal Aid, again, for the third time. I'm here to support this bill. Language accuracy is extremely important. A person's complete understanding of legal documents and terms, accurate explanation and understanding of medical symptoms, and or recitations of public health matters all require proper translation. It's well documented that poor language accuracy in communications can have devastating results. Language access policies exist but are generally not followed by state employees. Within the past few years, Legal Aid has provided legal assistance to thousands of clients whose primary language is not English. Over 65% of those clients interacted with a state agency or department. They are impeded while applying for governmental programs such as unemployment, temporary cash assistance, SNAP, simply because they are unable to communicate with people who work for the agencies. Most agency documents are only available in English, and when an agency provides translated documents, it does not include everything the client is expected to understand. Sometimes when asking for an interpreter, some clients never get a response. Others get contacted in English without an interpreter option. House Bill 1473 greatly increases access to Maryland state agencies and services to which these Maryland residents are unquestionably entitled. The law requires meaningful language access. The law still exists. Despite the executive order, Title VI still exists, and it's the Civil Rights Act of 1964. This must include outreach, clearer communication, and stronger oversight to ensure appropriate language access plans and resolution of violations. We strongly support House Bill 1473, and we urge this committee to issue a favorable report. Thank you.
Thank you very much, and I want to thank you again for sticking around the whole afternoon. We really do appreciate it. Questions from the committee? Okay, so Delegate, you've seen the fiscal note?
I have.
What are your thoughts on that fiscal note?
I think,
given our current budget situation.
Yes, I think we're definitely going to work that out to ensure that we're doing this with existing resources. Also, and just as a side note, because they were signed up to testify, but in your bill testimony packet, you would have seen testimony from the Public Justice Center, the Esperanza Center, the Maryland Equity Coalition for People with Disabilities, Howard County Autism Society, and the DD Council. But delegate certainly open to answer your question to amendments that would, address that question that you raised.
What I'm going to suggest is actually to work with the Department of Education, because it looks to me like what they're expressing, their concerns, is that something's already being done, but to do it in the way that your bill has presented it would actually pull in a lot of changes to a lot of the procedures in a lot of agencies. And that's, I think, what's generating the fiscal note. So if there's the opportunity for you to meet with them and see if you can get to some agreement about, because I think we definitely support language access. I mean, so there's no question that there's a commitment to people having access to written language and spoken language. But we have to figure out a way to get it done that can be done given our fiscal conditions, and that will be done in collaboration with the agencies that would have to be making the changes. Does that make sense? Okay. Any other questions, comments? Then thank you very much for being here. And I do have a number of speakers, so we'll see if there's anyone else here. Lisa Lorraine, Jamara Kochek, Ashley Woolard. I see the faint of heart here. Azeb Adair, Myra Laura, Stephanie Dollamore, Carol Pardo, and is there anybody virtual? I have Garrett Bradford and Sharon Manikin. No, neither one. Let the record show that we called everyone who signed up to speak on this bill. But we're very grateful that the delegate and Cornelia were able to stay. So with that concludes the hearing on House Bill 1473. And we will move to the last bill of the evening. And this is House Bill 1399. Delegate Arakan, Health Occupations, Cross-Sex Hormone Therapy for Minors, Prohibition, Protected Kids Act. Welcome to HGO, Delegate Arakan.
Thank you. I love being here with you guys, even at this late hour. You guys have really turned into the secondary judiciary committee. So I'm sorry for that, but I appreciate your hard work, and just know it doesn't go unnoticed by the rest of us who love to work past 10 p.m. as well. For the record, Delegate Lauren Arakan, and I'm here on HB 1399. The title basically tells you what the bill does. I will say I've drafted an amendment, but the amendments office has been a little bit busy with all the floor stuff going on, but it would also include, the ban would include surgery on minors as well. What I really want to have today is kind of a conversation about a broad policy question. But first I want to sort of tell you a story about a little girl. This little girl, she hated girly things. She hated frilly underwear and tights and dresses. She hated getting her hair washed and her long hair touching her back. She really didn't like playing with traditionally girly toys. She liked to build things. She only wanted to play with Legos. I don't know what her life would have been like if she had been born today, but she was born in 1984. This little girl didn't have gender dysphoria. This little girl had undiagnosed autism. That's what she actually had. And I know that because that little girl was me. And I was not diagnosed until I was an adult. But had I grown up today, I don't know how society or my family would have considered my behaviors. Would they have thought Perhaps she's in the wrong body. She hates everything we try to put her in. She hates having her hair long. All she wants to do is collect rocks all day, build things with blocks and Legos. Why isn't she like all the other little girls? There was nothing wrong with the body I was born into, but I was born into a world that my body didn't seem to fit into, that was uncomfortable for me. So what I want to talk to you guys about is some research, and I got a whole big old stack of it here. There is a lot of research coming out. I've got all kinds of stuff, and if you want it, I'm happy to send it to you. I didn't include it in your packets, but I do want to open the discussion that there are a lot of little kids, just like me, who think they were born in the wrong body, and it's because they have autism. That is what's going on. This research study from 2020, try to hold your laughter, guys. People can suffer and you don't have to laugh at them. In 2020, a study was done, 3 to 6 times more likely to be diagnosed with gender dysphoria if you are on the autism spectrum. 2019, the same story, especially for those who are assigned female at birth. They're much more likely to be undiagnosed with autism. There's not enough screening going on. And so my concern and why I drafted the bill the way I did, you may remember last year I came in with a very reasonable bill that asked for parental consent, which was not given a vote. The reason the bill is drafted as it is because what I believe and what my constituents believe is that what's happening with children who are being chemically castrated, losing their ability in many cases to procreate, is absolutely child abuse. And so I asked the drafters to draft this bill to reflect what I believe is accurate. What's happening to children is child abuse. This is the same type of abuse that occurs in third world countries where they are preventing girls from living their full sexual lives. This is unacceptable, and I believe that the state of Maryland is on the wrong side of history. We are going to be seen as on the wrong side of history. It may not be today, and it may not be tomorrow, but a lot of people one day are going to come down here and say, why did you let this happen to my body? We did have folks, detransitioners here earlier, but it's a big day. Not everybody can stay, and God bless her, she was able to have a baby, and so she had to go home to be with her baby. So that's why I'm here. That's why I wrote the bill the way that I did, and I will turn it over to my panel.
Good afternoon. I'm Jonathan Alexander. I'm an attorney and legislative counsel in support of this proposal from the Maryland Family Institute, in support of this proposal to ban cross-sex hormone therapy for minors as treatment for body image crisis. You know, this bill is long overdue. Medical authorities throughout the world and in many states have increasingly recognized that these procedures are harmful. They've been refuted, and now the defunct World Professional Association of Transgender Health, WPATH, has been exposed by its rhetoric and its experiments. And these are experiments. They lock kids into a lifetime of confusion and body shaming. It's not treating gender dysphoria. The great majority of children found to have gender dysphoria stop these thoughts as they get through puberty, and the rest of them deserve tender hand-holding, conversations to help them. But they do not deserve hormone regimens that are severely understudied, that leave them with a lifelong worth of damage to the minor's reproductive capabilities and have many other adverse medical effects. You know, the opposition will tell you that without cross-sex hormones in minors, that there's an increase in suicide. Well, that's an argument of deep duress, but it is not informed consent. You know, folks, I know that there's a lot to unpack here. There's a lot that's been said. But at its core, we need to be telling our children that they are loved and that they are cherished and that they are beautifully created, and they were born in the right body. And that young man, young woman, you do have the inner strength to overcome any adversity that is placed in front of you, including confusion issues. Even if you struggle as an adolescent, those ideas can dissipate. You'll hardly remember the days when you struggled about who you were during that time. But they'll be grateful to us that we did not lock them into chemical treatments and to a lifetime of changing their body. we should outlaw this practice by giving this bill a favorable report.
Thank you. Sir?
Thank you, Madam Chair and members of the committee. My name is Ismail Royer. I am Director of Islam and Religious Freedom at the Religious Freedom Institute, a nonprofit organization based in Washington, D.C. that advocates for religious freedom for everyone, everywhere. And I'm here today to express my support for HB 1399, the Protect the Kids Act, because it protects the fundamental rights of the people of Maryland in two important ways. First, there are people of faith in the medical profession who have strong and sincere religious objections to participating in procedures that disrupt the healthy development of children. By prohibiting the use of cross-gender hormones, then this bill would protect the rights of those workers in the healthcare profession. There's one study that shows that up to 1/3 of members of the medical profession have religious objections to dispensing these kind of treatments to minors. And second, this bill would protect the rights of parents because, as Delegate Arkin said in her bill or expressed in her bill last session, right now, children from 16 and up can receive these treatments without parental consent. So this bill, by prohibiting it, would protect the rights of these parents. And if it be said that, well, what about those who have conscience rights that would like to have these treatments prescribed to children, or what about those parents who would like to have this done, then those rights do not extend to procedures that would harm children. And these procedures harm children. And so conscience does not protect that. And so therefore, I urge a favorable report on this bill. Thank you.
And thank you all for being here and staying so late. I do appreciate it. Questions for the sponsor or her panel? Delegate Shalega.
Thank you, Madam Chair. Thanks for this bill. Delegate Arkin, what can you tell us about the impacts of surgery on children? I know you have quite a bit of research.
Yeah, there's been some new research. This is very interesting, published February 25th, 2025. It included over 107,000 patients and matched cohorts. And what they found was that people that are undergoing surgery, they're actually males specifically that had surgery, had a higher rate of depression, 25.4%, versus those who did not have surgery, 11.5%, and anxiety after surgery, 12.8%, versus those who did not have surgery, 2.6%. Also, females were looked at as well, 22.9% versus 14.6% for depression, anxiety 10.5% versus 7.1%, and there was other things that they looked at. But this is brand new. This is people who have been diagnosed with gender dysphoria, who have undergone the surgery, having adverse outcomes comparatively to the cohort who did not experience surgery. That really flies in the face of what we have been told, which is that we're saving people's lives by this gender-affirming care. This research shows that is not what's happening. It's actually making a statistically significant worse outcomes for those who are going through surgeries. So that is very, very concerning. Another study from 2024, this was published right after our hearing last year, that found a very similar outcome. The results of the study indicate that patients who undergone gender-affirming surgery are associated with significantly higher risks of suicide, self-harm, and PTSD compared to the general population control groups in this database. So these are new studies, and these are not coming from our side. These are actually coming from, this one is from an institution that does gender-affirming care. So it's new information is coming out every day, which is why I'm bringing it to you guys, which is why I feel so strongly about and why I drafted the bill the way it is.
You said 107,000
yes.
in this study, so that's a huge,
massive database of outcomes.
Yes. Thank you.
Yeah.
Any other questions? Yes, Delegate Morgan.
Thank you, Madam Chair. Delegate, we passed this bill, I believe, a few years ago, dealing with transgender and children. Since that time, I remember something about, well, it's not HHS, but I guess it was whatever health organization that Great Britain.
Oh, yeah.
Do you have any information on that?
Yeah, they've reversed a lot of their policies. Not just Great Britain, but several other countries have also reversed their policies on cross-sex hormones. And look, I understand the information is new and it's coming out, but there's already countries that are leading on reversing their policies.
So my understanding is they had it legal and then pulled it back.
Yes.
Okay. Thank you. Thank you, Madam Chair.
Seeing none, thank you very much for being here.
Thank you, Madam Chair. Thank
You're
you all.
welcome. Let's call Prisha Mosley, Paul Modrell. Is there someone virtually? Can you pull them up, please? Actually, let me go because this is a favorable panel. Let me see if there's any, just to be balanced, favorable. Is Miles Riggs? Can you come up, please? Sir, what is your name?
So I heard my name, Paul Modrell.
Can
Am I
you-
supposed to be taking my seat?
Can you please just wait a second? I'll call you back.
Okay.
Okay, I try to sort of call a favorable and unfavorable to be balanced in this committee. So let's see if Andrea Corey, are you here? Can you come up, please? And Jennifer Warwick, if you can come up. That's 3 and 3. All right. You can get started.
Okay. Thank you for having me today. Thank you for having me today. My name is Miles Riggs. I am a 17-year-old high school student. I'm a senior in high school in Montgomery County. I've lived in Maryland with my twin and my parents most of my life. Me and my twin are both members of the LGBTQ+ community. I came out as trans to my family in 2020 at the age of 13, but I'd known that I was trans since I was 11, and I'd known without having the language that I wanted to be a boy since I was about the age of 5. I began looking into getting hormone therapy around the age of 15, and after having wanted it for years. And I started weekly testosterone injections in October 2023 at the age of 16. I was incredibly lucky to be able to start this hormone therapy before the age of 18, and my parents, while supportive, were hesitant about me starting hormones before being an adult. In the end, it was a long conversation between me and my parents about how I respect their wishes, but I was going to start hormones either way, and it was more a question of what kind of relationship they wanted with their son and how much I was struggling with my mental health. This is because, like so many people, hormone therapy was life-saving medicine for me, and I do not regret it for a second. In fact, regret rates for medical transitioning are incredibly small. Most studies find less than 1%. Not to mention that banning gender-affirming care to minors will also ban hormone blockers. Hormone blockers are simply treatments that block the progression of puberty and allow kids thinking time to figure out if they want to proceed with hormone reassignment therapy, like gender reassignment therapy. And it can save a child from going through a very painful puberty, which is very hard to describe. It is like wanting to claw yourself out of your own skin rather than live another day the way society sees you. At the end of the day, all I'm here to say is that the decision for a child to go on hormone therapy should be up to the kid, the parents, and their doctors. It should not be up to the law. But I get it. A lot of people right now will hear the word trans and they will just tune out my argument. I understand that words have meaning for everyone and not everyone likes the word trans. Let me sum this up in a way that all of you can grasp. I am simply a boy, a young man, trying to argue against a bill that will ban health care to children that has been and can be life-saving. And I am angered by a lot of states that pass bills like this because a lot of them, the arguments against trans people are based in lies and extreme exaggerations and studies that are not cited well or underexplained. And I really hope that you think of that thing, Protect the Kids Act. What kids are you protecting? No one is being given this unwillingly. Thank you for your time.
Thank you, and I know, Miles, that you waited all day. Like everyone else, I thank everyone for waiting to give your testimony, and I thank you for, for being with us today, and I thank you for sharing your story, okay? Because it matters. and you're being heard, okay? Who's next?
Go ahead. Sure. Hi, my name is Jennifer Zorich. I am a clinical social worker. I've been in mental health care for over 20 years, and I'm also a mother and a parent of a trans teen. And that's the main reason that I'm here today. I'm here because I believe in self-determination and authenticity, and I believe that the intersection of mental health and taking care of our children needs to be at the forefront, as opposed to legislating and restricting their care. And I want to take a minute to tell you a little bit about my child. I've had the privilege of watching both of my children develop their own unique personalities and strengths as they weave through their own individual struggles. My child, my oldest child, just turned 18 this last year. He has been and always will be an amazing human being. He has thrived throughout his childhood, loving to learn and listen and read and climb trees and play the trombone and be in marching band. And he, like many people and teens, struggles with mental health. He's dealt with severe anxiety and depression, and when this persisted, even with mental health supports in place, I felt that we needed to have more specialized care because I was concerned for the ability of my child to be able to make it to his 18th birthday. And that is not the case for every trans or non-binary child, but it was the case for mine. His connection with gender-affirming care providers was transformative. I could see my curious kid come back. He was being seen for who he really is, and that saved his life. I'm grateful that my son is now living authentically. And today, this brilliant student, this AP scholar, is enjoying senior year time with friends and is trying to decide between 6 different colleges and universities in their honors programs. I just want, for one moment, for you to take time to think. Your job as legislators is not to restrict access to health care. It's not to discriminate against any population. We, as your constituents, need you to allow us to have access to all of these supports that are out there for our children and for ourselves. Thank you.
And thank you for sharing your story. We appreciate it. And your child is very lucky to have you, very blessed to have you. Next, please.
Thank you, Madam Chair. My name is Andrea Corey, and I'm a lifelong resident of Maryland, and this is my first time ever testifying. While I'm a registered Democrat, I was raised a Republican, and I went to Catholic school for 18 years, and I'm testifying to oppose this bill. And while I don't think this is going to pass in Maryland, I did feel compelled to be here today. This infringement on my right to direct the health care for my child is surprising coming from Republicans. I have a constitutional right to raise my children as I deem appropriate. The standard for states infringing upon that right is significant, and it should be significant. Why do you think that you know more than I do about how to raise my child? Objection to government interference in my rights as a parent has been central to the Republican value since before the Reagan days. I'm not understanding this move in Republican values away from small government towards the government interfering in my rights as a parent. To be clear, this bill is not talking about kids in sports. To be clear, this bill is not talking about a bathroom. This bill is restricting my right as a parent to direct the health care of my children. The sponsor said this is child abuse. I've been a child abuse and neglect attorney for 30 years. I assure you this is not child abuse. Maryland allows parents to be homeless and have their kids. Maryland allows parents to inflict corporal punishment on their kids and keep their kids. Maryland allows parents to give birth to drug-addicted kids and keep their kids. This is not child abuse. So in sum, I encourage this committee to not pass this bill through this committee. Thank you.
And thank you for the work you do and sharing your story. I'm going to open it up for questions now. Are there questions for this panelist? Okay. Thank you so much. Appreciate your testimony today, okay? And get home safely. We're going to go to now, going back to the favorable. And we have Lisa Gerathi. Is that person here? Okay, why don't you come over, sir, and give us your name and your testimony. Is Kit Hart here? Sir, you can come over. Paul Modrell, you can come over. Is there Kit Hart, Janine Canito, and Lisa Gerathi? Okay. Anyone else that is favorable that has not been called, who's in the audience? Excuse me, virtual? We're going to bring them up. Go ahead, sir. You can get started.
So my daughter was normal. She loved princesses and glitter and all that sort of stuff. Then we sent her to public school. By age 11, she'd been convinced that she was a lesbian because she didn't like boys. Her freshman year, she shaved her head, she dressed like a boy, and she went by a different name at school without me knowing. She developed anxiety, depression, suicidal thoughts. It got worse. Her junior year, she got so bad at one point, my wife and I actually had to call 911. No matter, we gave her all the love and the support we possibly could, therapy, medications, nothing seemed to work. Then she graduated high school, and the clouds opened up, the sun shone through. She actually lightened up. She started dressing like a normal young lady. She met a boy at community college, and she has a boyfriend now, and she's the happiest person that you could find. She's on the road to recovery. The problem is, this starts in school with the new curriculum. Some of these teachers, they actually get into the heads of these kids and convince them that maybe they're LGBTQ, and then they try to live up to this new identity, a false identity. And it went against every fiber of my daughter's being. That's where all this emotional turmoil came from. So, but she pulled through. But what if we were these woke parents that actually fed into it and taken her to a doctor that would put her on hormone therapy and maybe removed her breasts, only to graduate high school, all bearded up, realizing she wasn't trans at all. So thousands and thousands of kids are actually mistakenly, irreversibly taken down this path by bad doctors. Yeah, and then they have to detransition. You laugh about the beard? These people go through hell with electrolysis, getting their hair off their faces and everywhere else. So let's pass this bill and bring these doctors to heel. And then let's do something about the schools that created this pipeline for these bad doctors. They're generating kids that don't belong with that group.
Thank you for sharing your daughter's story. And let me ask and see if there's any questions, sir. Any questions for him? Okay.
Questions?
It's okay. Don't worry about it. There
this
are
is
no
my first time doing this kind of thing.
No,
I'd be
there's no
glad to answer any questions.
No questions anyway. Thank you, sir. Thank you for
None.
sharing your story, okay?
Thank you.
You are welcome. You know, it is 9:42 in the evening, and I am only missing 2 of my members, 2 out of 24. So we are listening to you, both sides. It doesn't matter. This is a committee that is thoughtful, like all the other committees here, and caring. One member, his wife is sick, and the other one is over there on a phone call. So I have 23 out of the 24. So you were heard, okay? Because we do care, regardless of where we are on the issue, because this is your time, and you came here and you're waiting this long. So thank you. I appreciate you. Next, let's go to, why don't we go to the people that are virtual? Can you bring them all up, please? Are they there? Okay, great.
Good evening, Mr. Mosley. Will you be so kind and unmute yourself and give us your testimony?
Thank you very much. I presume there will be a clock there. Let me say that I am a physician epidemiologist. I have expertise in human reproduction. And I want to say I'm also an emeritus professor at Johns Hopkins, but I am not speaking for Johns Hopkins. I'm speaking personally. I've read over 150 scientific publications about gender-affirming care for minors. And here is basically the bottom line. There is some evidence from short-term studies of 1 or 2 years or so that providing hormones, cross-sex hormones, to minors provides some relief of gender dysphoria and some relief from some other mental health symptoms such as depression or anxiety. However, there are no long-term studies yet available. So we don't know what happens after 5 years, 10 years. And there is concern that these cross-sex hormones do have adverse effects such as cardiovascular and blood clots, among other things. We do know that there is one effect that is becoming very apparent, and that is that more and more young transgender children, or I should say young adults, are now detransitioning. They are regretting decisions they made as a child and are making efforts to reverse their gender transition. Let me say that we don't know the precise numbers. It's claimed that it is rare. One problem is that there is no diagnostic criteria or ICD to classify persons who come in for detransition care, so we don't know the number. I can say from websites, one which has 57,000 detransitioners registered, and another one which has over 11,000 detransitioners registered, that the numbers must be in the tens of thousands of persons who have now detransitioned, young people. Typically, this may occur between 5 to 10 years later when they are young persons thinking about, for example, getting married or concerned about sexual pleasure.
Sir, you have to wrap up. I try to give you some grace, but can you please give me your last thought?
Okay, my last thought is that the University of Maryland, the state of Maryland is not the only place that's concerned about this. A number of countries, including United Kingdom, Sweden, Finland, Denmark, France, and New Zealand, have severely restricted hormone therapy for minors with gender dysphoria. They require long-term psychological support. Thank you.
Thank you, and thank you for being with us this late. We appreciate you. Are there any questions for this gentleman? Seeing none, thank you so much, doctor. You have a blessed evening.
Thank you.
You're welcome. Are there any favorables that are here waiting? You can't, all right, so I'm gonna call the following for now. Andrea Corey, Jennifer Warwick, Chloe Celeste, Jeremy Browning, Joe Bryan, can you come up, please? Lee Blinder, Charlotte Hoffman, and you can pull a chair up, please. And can you bring the virtual people too, please? And if you can just get started, please, someone. And pull the microphone closer to you.
Good evening. My name is Jeremy Browning. I use he, him pronouns, and I'm the director of the Maryland Commission on LGBTQIA+ Affairs. I'm here on behalf of the commission in strong opposition to House Bill 1399, which is a dangerous and unnecessary attack on transgender youth and their families. This bill is not based in science, medicine, or the well-being of children. It's based on fear and misinformation. This bill contradicts the overwhelming consensus of major medical organizations, including the American Medical Association, the American Academy of Pediatrics, the American Psychiatric Association, the Endocrine Society, and many others, all of which recognize gender-affirming care as safe, evidence-based, essential, and often life-saving health care. I'll defer to our written testimony for the other numerous reputable sources. Denying transgender youth access to health care will not change who they are, but it will put their lives at risk. The data is clear. Restricting access to gender-affirming care increases depression, anxiety, and suicidality among transgender youth. This bill undermines parental rights and physician expertise, interfering with the ability of parents to make informed medical decisions with their children, despite research affirming that supportive families and access to gender-affirming care significantly improves long-term health outcomes. These are deeply personal medical decisions that should be made between a patient, their parents, and their doctors. HB 1399 is an extreme and dangerous bill that disregards medical science, threatens the well-being of transgender youth, and criminalizes healthcare providers and strips parents of their ability to make informed healthcare decisions for their children. And for those reasons, the Commission strongly urges an unfair report on HB 1399. Thank you.
Hello, thank you, Chair. Charlotte Persephone-Hoffman from Trans Maryland. I think I submitted my longest written testimony to this committee in the form of my written testimony here. I think it was like 9 or 10 pages, going through all of the medical societies, like every major medical association in the United States that has opposed bills such as HB 1399 that would restrict the ability to access transition-related care for minors. One thing that I really want to hit on is why so many medical societies are opposed to this. And it's because bills like 1399 are a one-size-fits-all solution that does not look at the individualized needs of the particular child or teen or whatever. They say, oh, no teens at all ever need this. And so it's safe to outlaw it for everyone. And that's simply not true. Now, it might be that we underdiagnose autism for people who are assigned female at birth. That is absolutely true. And I would be up here in support of a bill that says we need to increase funding for autism screenings, et cetera. But that's not what this bill is. This bill is saying we need to criminalize something that's unrelated to autism. I also want to talk about my own child who's 14 and who is having their own experience on the transgender spectrum. They were assigned female at birth. They are somewhere in the non-binary to trans boy arena. They're figuring that out. But I, as a trans advocate, am not saying, oh, Thessaly, you need to rush out and start taking puberty blockers. You need to start taking testosterone right now. I'm saying, let's do what's right for you. Let's figure out things on your timeline. And that's what we're doing. And that's what parents throughout Maryland are doing. We don't need a one-size-fits-all ban. Thank you.
Good evening. My name is Chloe Celeste. I live in Legislative District 4 and I'm 16 years old. I'm also transgender. I was assigned male at birth, but when I was 13, I came to understand that I could no longer live my life as a boy. Since starting gender-affirming hormone therapy with the guidance of my doctors and my parents over a year ago, I have been more confident, self-aware, and overall happier than I have ever been in my life. And anyone who knew me pre-transition can vouch for that. I am the exact person HB 1399 targets. The so-called Protect the Kids Act would force me and all other minors receiving gender-affirming care in Maryland off of our life-saving medication. This is disgusting. It's akin to outlawing insulin for diabetics, and every major medical association recognizes that losing access to care is detrimental to the health and safety of our trans youth. Well-established science has proven time and time again that trans people know who they are and benefit greatly when recognized and validated. Puberty blockers, which this bill seeks to outlaw, are entirely reversible and have been used for decades in children with precocious puberty with very little side effects. A study published in December 2022 by a prestigious medical journal known as The Lancet shows us that over 98% of trans youth who begin taking puberty blockers will continue We'll continue on to hormone therapy well into adulthood. All medical treatment is based on the model of cost-benefit analysis, and statistically, the benefits of gender-affirming care greatly outweigh the cost. Just for an example, knee surgery has a regret rate as high as 20% as shown by an NIH study. Why aren't we outlawing knee surgery for minors if it has a regret rate 10-fold greater than that of gender-affirming care? If this bill is passed into law, it will literally kill people. The suicide risk among trans and non-binary youth when denied critical health care is 73% greater than that of their appropriately medically treated counterparts. I, for one, would not be alive if it wasn't for HRT. We the people means all the people. Whether the Republican delegates here like it or not, they are forever going to have transgender constituents. It is literally your job to represent the most vulnerable among the population, and it seems as of now that you're doing everything you can to oppress the most vulnerable among the population. Majority rule, minority rights. This is a basic tenet of any democracy, but it seems as if the 17 delegates who sponsored this bill have forgotten that simple fact.
Thank you for sharing your story. Next, please.
Good afternoon, Honorable Chairwoman, Vice Chair, and esteemed committee. My name is Lee Blinder. I use they, them pronouns, and I'm a very proud transgender adult. I'm also the Executive Director of Trans Maryland, and I am the Chair of the Maryland Commission on LGBTQI+ Affairs. I'm here today on behalf of Trans Maryland to register strong opposition to HB 1399. Y'all, frankly, this bill is a waste of everyone's time. We know that our opposition does not have a strong understanding of science or biology. To that point, to illuminate that point, I have one comment. Trans mice. Y'all know what to do on this bill. Thank you.
Next, please.
Good evening. My name is Joan Bryan. I'm a resident of Baltimore County. And I want to tell you about my trans grandson. We knew that my granddaughter was a boy from the time he was in kindergarten. We used to buy girly toys and that sort of thing, and he never touched them. In fact, he would convert the toys to something more masculine before he would play with them. When we went shopping for clothes, there was always this argument. I would go to the girl side, he would go to the boy side. Finally, we made a bargain. He could have one piece of boys' clothing for every 2 pieces of girls. And he settled for that for a while. What else do I want to remember? And he did okay for a while. I think the turning point came when they had their 6th grade going into junior high prom. Before that, he would wear grungy, just nondescript clothes and put his hair up in a top knot, and he was fine doing that. Because back then, everybody looked like that, so he was fine. But when time came for this prom, his family insisted on a prom dress, and getting his hair done, taking down the top knot and making this really wavy hairdo done by a hairdresser. And he went to this prom. I've never seen a sadder prom picture in my life. It was so bad, we didn't keep them. Eventually, we noticed that he was beginning to cut himself. At first, it was little nicks and scars that weren't that major. Then he began to lock his door, and we found really heavily blood-stained items in the laundry. The family decided to find help, and we were lucky enough to find a practitioner who provided psychological care and hormone therapy. I'm telling you, if we had not found this person, and he had not gotten that care, I don't think he would be alive today. I really want you to think about my grandson and the thousands of other trans kids in this state who weren't as lucky as mine and may not live to see adulthood. Thank you.
Your grandson is very blessed to have you as a grandma. Thank you for being here and sharing the story. I'm going to open it up for questions now. Are there any questions for this panel? Seeing none, I want to thank you, and thank you to everyone who's been waiting for being with us, okay? You have a blessed evening. Let me call the next panelist. Thank you. I think, is there anyone here in committee that has not been called? If you have not been called, will you come up, please? Will you be so kind and bring everyone that is virtual? They're in, please bring them up. Thank you. Is there anyone here in person that has not been called? Whether you're favorable or unfavorable? All right, let's just finish with the virtual ones and we'll be finished for the evening. I asked the committee to sit for a minute, so because I need to do the assignments for the floor. Thank you. Whoever's in, will you be so kind and start giving us your testimony? Unmute yourself. Thank you for waiting this long. We appreciate you. Please unmute yourself. Are they in? Okay, I'm not looking, seeing them. They're all muted. Okay, why don't you go ahead, Megan Staller, why don't you get started?
Okay, thank you. Good
You're
evening,
welcome.
Chair Pena-Melnick, Vice Chair Collison, and honorable members of the committee. My name is Megan Stallard, and I'm a cisgender student at Poolsville High School, urging an unfavorable report in committee on HB 1399. Delegates, the Save the Kids Act actually does no such thing because gender-affirming care isn't harmful for transgender youth. A study in the Oxford Journal of Sexual Medicine found that just 1.4% of transgender people who began taking puberty-blocking and gender-affirming hormones as a minor went on to detransition. Another study of 55 youth who had taken hormones before the age of 18 found that none of them, not one, regretted that later in life. Far from saving the kids, this bill puts transgender children in danger. Gender dysphoria is the distress caused by the disconnect between a person's gender assigned at birth and the gender that they identify with. Nearly one-half, or 48.4%, of individuals with gender dysphoria suffer from suicidal ideation. However, according to a meta-analysis by NIH, gender-affirming hormone therapy significantly reduces gender dysphoria. This bill removes access for trans youth to life-saving treatment, which directly reduces their risk of death by suicide. Also, hormone therapy is already difficult to access for minors. Parental consent, medical history, and multiple consultations are all a part of this long and arduous process. Choosing to take gender-affirming hormone therapy, especially for minors, isn't a decision made on a whim. Corroborating this, the number of minors receiving gender-affirming surgery is incredibly low. Just 0.4% of transgender minors receive surgery. And gender-affirming care, including surgery, is considered safe and appropriate by over 1.3 million doctors across the U.S. Banning this care displays disrespect for the medical expertise of the professionals who prescribe it, and complete disregard for the safety and well-being of transgender youth. Though disguised as a protective measure, in reality, this is a discriminatory and harmful piece of legislation targeting one of our nation's most marginalized groups. For these reasons, I strongly urge a negative report in committee on HB 1399. Thank you.
Being with us. Where did she go?
Sorry,
Okay. Okay, just wanted to say thank you, Megan, for being with us. Let me see if there are any questions. Any question for Megan? Thank you so much. Your parents must be very proud of you. Great testimony. Next, please.
Hi, good evening. My name is Alexa Shudo, and I am a public school teacher. It is my seventh consecutive year in that role, despite Lauren Erickson's best efforts. I have seen the impact firsthand of obstacles between young people and the means for them to exist authentically. When it comes to efforts like Lauren Erickson's this evening, trust me when I say the cruelty is the point. Every accredited medical board or association opposes the bans on HRT, and their findings on this do not align with the claims made here tonight by Erickson and her panel that don't have the same qualifications as those in those associations. That it is experimental, and there is no evidence of a high rate of regret. In fact, there is a more demonstrably high rate of regret among heterosexual marriages, and we love those. I'll be here all week. Regardless, this bill is a moot
I guess
point.
we must be tired, but go ahead.
It's all good. Regardless, this bill is a moot point. In Maryland, a minor cannot get medication without parental consent or surgery. I looked that up while Lauren and Kathy were doing their cute little skit they wrote during questions.
Can you call them Delegate Shalega and Delegate Arikan? They're delegates, okay?
All right,
Let's just be respectful, okay?
Sure.
Okay, thank you.
The only group this would affect is 16-year-olds whose parents signed off on the treatment that they are receiving. All the kids that want HRT, but their parents don't agree with that, already cannot get HRT. Delegate Arikan, why do you think that the government ought to supersede parental rights? Are parents not the expert on their child's well-being? Or is this about power and control? I'm done.
Thank you for your testimony. And you know what? Thank you for using your voice, okay? It's always welcome. I just always respect the role, and that's important.
Absolutely.
But I appreciate you being here, okay? Are there any questions? And thank you for teaching, because it's so hard and you don't get paid enough.
Oh, I'll keep teaching.
Have a blessed day, okay? Blessed evening. Can you bring the rest of the panel? There. Okay, who's next?
I'm the last one.
Yes, you're the last one.
Yeah.
But we're still listening to you, so don't worry. Give us your testimony.
All right. Good afternoon, honorable committee delegates. My name is Richa Tripathi, and I'm a junior at John F. Kennedy High School in Montgomery County. I'm actually a lesbian myself, and I don't like boys, but I developed anxiety and depression, not from being gay, but from coming to testify actually in environments like these in the past few years, where I feel angry that this is a bill to begin with. For the sake of protecting the kids, as this bill attempts and fails to accomplish, I urge an unfavorable report on HB 1399. I had a beautiful, fact-based and practiced testimony written out to impress the delegates of this room, but instead you will hear something that I wrote in 10 minutes while I was listening to this panel. I hope you will be kind with my stutters. Just know that I'm speaking from the heart, not just a haphazard script. Delegate Arikan, I want to speak to you directly for a second, because I wanted to tell you a story about a little boy. This little boy didn't mind girly things. He just minded being called a girl because he understood that he wasn't. This little boy was born a girl but is a man now. I met him when we were 10, when he went by she, her pronouns, then they, them, and now he, him. I knew him when he changed his style of clothing, his pride flags, then his name socially, then legally. All things that most transgender kids do before they even seek a surgery or gender-affirming care to begin with. I read my testimony to him during lunch and fourth period today. You may not have shared this experience, but you cannot speak for everyone. And when I think of your argument, I think of him. I apologize if you feel offended by these statements, and I respect your right to express your opinions and have your own legislation passed. But how dare you use that experience to negatively discuss life-saving surgeries in a room with transgender students, delegates, and humans? Several other students, transgender students who needed that care, wanted to testify today, but didn't because they were afraid of this hostile environment. And maybe they should have been, and maybe they shouldn't have, but they sent me instead because I'm not afraid of this. I'm just tired. You asked to protect the rights of the parents, but it's actually proven that in Maryland, when minors are involved, parental consent is explicitly required. I also Googled that during the thing. Just for my closing statement, I'd like to say Lee Blinder said it perfectly, and I'd like to say it again. This is ridiculous. That's all.
Are there any questions for this witness? I want to say you could tell your friends that they're welcome here, right? And that we will give everyone respect in this room, no matter what your position is. And I want to thank you for being brave for your friends and for coming. And I really want to thank you on behalf of the entire committee for giving us your testimony, okay?
Thank you.
All right. Delegate Chisholm, you have a question.
Statement. Thank you, Madam Chair. And look, I'm proud of everybody that thinks they're brave, but I want to say it takes a lot of courage. When the masses are against you and we are sitting here being blind as Republicans, when Delegate Arikan came up here and every one of them used her name and they wanted to berate her, that's not great.
I wasn't
takes courage.
sitting in
I know
this
you
chair.
didn't. You know I've never taken anything. I love you. I just want to stand up for Delegate Arikan, who had to sit back there and listen to all of this. It takes courage. when she knows all the numbers are against her and she's going to hear this. It takes courage for that person to testify and everybody to testify. It's a very daunting task. So I don't think that we should be saying this person is courageous and this person is not courageous. Everybody that testifies is courageous because they testify on what they believe. And nobody testified on something.
No, that's not allowed. Don't say that. Okay, first of all, from the minute I sat here, I gave everyone respect. Okay? And I said, I thank everyone. And I mean it. Because look at the time. It is 10:08. And we're all here. Okay? And we're hungry. That's right. So I gave everyone respect. And especially when they're young people, regardless of who you are and what position you have, they are brave. Because to be at that age, I never would have done what they just did tonight, because I didn't have it in me to do it, okay? So everyone here was respected. I haven't seen any disrespect since I've been sitting here, and when I did, I corrected her immediately, all right, to address both delegates with their title, all right? That's how I run this committee, and I give respect, but I expect respect, and it doesn't matter who you are. Okay, because life is too short and we work too hard. Okay, so thank you, everyone.
Madam Chair,
No, you cannot. You cannot.
I was just
Thank
wondering
you.
if it was a
No,
question for me.
no.
Okay, thank you.
All right, everyone, have a blessed evening. Thank you for being here, and we really appreciate you. Okay, for the committee, can you stay here a second so that we can do the assignments? Okay. Oh, you're welcome. You're always going to get respect here, but I will call you out when you're not being respectful, so we don't yell, okay? You know what? That's not right. No, you're not right. You're not right to say that. Okay? It's okay. It doesn't matter who you are. When I see it, I'm going to call it, okay?